Can start. Good morning. My name is Ruta Vaičiūnienė, and I am delighted to see you all here today in our project final conference at the end of this project 2.5-year journey. This project was dedicated to analyze individual assessment of suspected or accused children in the light of the Directive 2016-800. And the research within the project was based on semi-structured interviews which were carried out in 4 countries: Lithuania, Croatia, Greece, and Cyprus. So, as I mentioned, we conducted semi-structured interviews with professionals doing and using individual assessment in their daily practice. And today I am even more delighted because I have opportunity to present you our final result of the project, which is now freely available in the website of our institute, Law Institute of Lithuania. And this is a book, and it is also available not only in English, but in Lithuanian, Croatian, and Greek languages. So you can easily go and download it and read it, of course. I'm really extremely happy that we managed to put all findings into this book. And that's why I would like to use this floor to thank to the people that that contributed to this book. Firstly, I would like to thank to the team of our institute and also our partners from the Zagreb University, from the non-governmental organization Hope for Child, and Aristotle University of Thessaloniki. As well as I would like to thank our language editor and advisor and really a good friend of ours, Avril Calder, and reviewers of the book. But especially I would like to thank all professionals that agreed to participate in the research and shared their knowledge and experience. Without them, this research, this book wouldn't be possible. So now I will go through very shortly because you will find everything in detail in the book. So I will present very shortly the main results, the main findings that are presented in the book. Just a minute. Yeah. So as you may know, all of you very well, that directive establishes only general principles for member states on implementation of individual assessment, but leaving member states of making their own decisions and choices how to implement it. So, and each country choose their own way. And individual assessment itself as an instrument or as a tool allows to meet, let's say, 2 main goals. The first is an individual assessment could be considered as an evidence-based decision-making tool, which helps in criminal proceedings and helps to meet children's needs in earliest stage and in each stage of criminal proceedings, especially when we are talking about decisions, about procedural decisions and sentencing decisions. But as well, this instrument allows us to reach child-friendly decisions as possible as child-friendly decisions. So enables us to hear children, to represent, to encourage them for their active participation in the process, hence to ensure the best interest of the child. So the main challenges, let's say, of implementation of individual assessment to harmonize these two goals. The harmonization firstly depends on the approach that countries choose. Do countries implement individual assessment in very formal way because they lack of resources or they lack trained professionals? Or do countries stress mainly on evidence-based instruments, for example, risk assessment? Or do all professionals work in collaboration and are oriented towards impact of individual assessment? All these questions and challenges that you see in the slide, all these challenges helps to answer a question about harmonization of decision-making, of evidence-based decision-making, and best interest of child-friendly politics and practice. So I believe that that today we will discuss a lot about harmonization of these two goals, and I believe that I am sure that we will hear inspiring presentations, and we will able to answer this question. So I am really excited to be here, and I am thankful for each and everybody, and to wish you very fruitful discussions today. So I'm giving the floor to Avril, our moderator of first section. So Avril, the floor is yours.
Good morning, everyone, to those I know and those I do not know. I'd like to welcome you all here today to what I think is going to be a very illuminating examination of the important work that goes on in assessing young people, children and young people who come into conflict with the law. And to start off today, we have Professor Stephanie Randall, is someone I do know and have known for a long time. And Stephanie is an expert in children's rights at the Department of Child Law at Leiden University Law School in the Netherlands. And I know that Stephanie, apart from being an expert in children's rights, is also an expert on the particular right of participation. I don't know what she's going to say today, but perhaps she will be shedding some light on that. So Stephanie, I can't see you on the screen, but I think you must be there somewhere. Would you like to speak now?
Yes, I am.
Good morning, Stephanie.
Hi, welcome. Thank you. May I share my screen?
I can't do it. Tamash will do that.
Sure.
Yeah, I will start sharing my screen first. Okay.
Perfect.
Yes, okay, great, it works. Thank you very much for the invitation to speak today about individual assessment of children in the justice system. Thank you for the kind introduction also. I work at Leiden University, the Department of Child Law, and I will mostly focus today on the legal background of individual assessment and where it comes from and why it is important also. to conduct individual assessments on children who are in conflict with the law, so to say. Oh yeah. Yeah. So first, I would like to shed some light on the international children's rights framework in this regard. Already in Beijing rules, which were introduced in 1985, before the adoption of the UN Convention on the Rights of the Child, we saw that individual assessment had a place in this document. The Beijing rules are guidelines for UN member states on how to implement a juvenile justice system. There already in rule number 16, it said that a social inquiry report is needed in cases where children are suspected or accused of having committed an offense. And it is important to understand the background and the circumstances of the young person, to also understand why this young person has committed a crime. And also that the competent authorities should be informed, for example, about the social and the family backgrounds, the school career of the young person, and also other educational experiences. Another important aspect of the Beijing rules is that it also emphasizes that the well-being of the young person should be emphasized in the justice system. And that means that also the aspect of proportionality should be taken into account. So that not only the seriousness of the offense is of importance, but also the circumstances of the young person is of importance in understanding what kind of response is needed. And that these two things need to be balanced in order to come to a disposition that is in line with the needs of the child in that particular situation. The UN Convention on the Rights of the Child in Article 40 has really built upon the Beijing rules, and it has as important underpinnings that on the one hand, young people need a fair treatment in the justice system, that they have the right to certain procedural safeguards, such as representation, for example, an independent judge who will look at their case, and the right to be informed about their charges, for example. But on the other hand, it also stresses that children need a child-specific response, and that it should be different from how adults are treated in the justice system. For example, of course, in the convention, the best interest of the child is an important general principle, so that the best interest of children should be taken into account in all decisions that are taken, but also in relation to the justice system, that resocialization and reintegration are important aspects or goals of the system, that children should be reintegrated into society, and that further offending should be prevented. You may also know that the UN Committee on the Rights of the Child, which is the monitoring body of the convention, also gives recommendations to states. And in one of its latest general comments, number 24, it focuses on the justice system. And there it stresses again that states should install also specialized courts or units of courts where children are dealt in, children in the justice system. And that they also should have specialization in the police, for example, but also in the prosecution service. And also lawyers and representatives of children should be specialized in working with children and young people. And that means that, they say that also individual assessments should take place and that a multidisciplinary approach should be taken. This means that professionals should also be trained in other disciplines, that they should have knowledge not only on the legal aspects of cases, but also about the social and psychological development of children, including maybe some knowledge about the brain development of children and how it affects their behavior. And also that they should have knowledge about disparities taking place in justice systems, and that they have special attention for specific vulnerable groups in the justice system. The latest or the final document that I put on the slide are the guidelines on child-friendly justice, which are issued by the Council of Europe. And these guidelines have had quite an important impact on how the term and the concept of child-friendly justice has been developed in the last 10 years. And I will say a little bit more about, if I can go to the, that's the next slide. About how individual assessment should be incorporated also in justice systems. The guidelines on child-friendly justice are very broad. They do not only apply to children in conflict with the law, but also children who are in care and protection, for example, or in migration procedures. But they have some specific sections on children in the justice system. And they also highlight that assessment of the psychological, social, emotional, physical, and cognitive situation of children is of importance to make the system more child-friendly. That is also important to develop a common assessment framework. And I think that also relates to what Ruta just said about using also evidence-based tools to assess the needs and interests of children. That this should be done accurately and also through multidisciplinary methods, so that not only lawyers are involved, but also, for example, social workers, psychologists, and even maybe sometimes a psychiatrist if that is needed. Here it is also stressed again that professionals need to be trained in different disciplines and also need to understand about children's development and behavior by way of learning more about children's psychology. Then I think the important underpinning of this project also and of the whole idea of conducting individual assessments in Europe is the EU Directive on Procedural Safeguards for Children, in which one specific article addresses the right to individual assessment for children. It states that a multidisciplinary and robust individual assessment should take place at the earliest stages possible for suspected or accused children, and that it should also be taking place in a child-friendly way. The EU directive also has other rights enshrined in it, like, for example, that children have the right to information, so that they should be informed about the proceedings, but also about the charges, that they have the right to legal assistance during their case, that they also have the right that their case is treated in a timely manner, so that they do not have to wait very long for their case to be heard and assessed. And also they have the right to effective participation. And in the context of this EU directive, it means that children have the right to be heard in the court case against them during the trial. Again, also the specialization and training of professionals is also stressed in this EU directive. So to zoom in a little bit further on this aspect of individual assessment and what is needed from member states of the EU, it states that the specific needs of children should be assessed in relation to their protection, education, training, and social integration. That means that the child's personality and his or her maturity should be taken into account. And I think maturity is a very important aspect here, because in the justice system, we often speak about age limits, minimum age of criminal responsibility, upper age. But it does not mean that a child of 14 is always at the same level of maturity. That can depend very much on the child's development and his or her social background. Also, it is highlighted that specific vulnerabilities should be assessed, and that relates, of course, to maturity as well. Vulnerabilities can mean that a child has learning disabilities, for example, or is lacking in certain aspects. Also, it's highlighted that this individual assessment should not only take place to see what the final outcome should be of the case, the final disposition, but also in light of specific preliminary measures that are taken. For example, in a pretrial phase where a child is taken in pretrial detention, and sometimes this can also be, a child can be released under conditions, and then certain measures are taken. But in order to assess what the most effective measure is, the individual circumstances of the child should be investigated first. And in the end, it also states that the circumstances of the case and also the type of measures that can be taken also influence the type of individual assessment that is taken. So that means that states also have the leeway to, for example, do not a very extensive individual assessment in cases that are more lenient and where maybe less strict or invasive measures can be taken. For example, when you're talking about diversion, for example, or when very, where less serious offenses have been committed. Also, it is stated that if an assessment has been done in the recent past, then maybe only an update is needed and not a full, a new individual assessment. Of course, this is something that is also of benefit for states, because then they do not have to invest as much, of course. Okay, so when should it be undertaken, this individual assessment? It is stated that it should be undertaken at the earliest stages possible in the proceedings and before the indictment for a child suspect or accused person. But it is also stated as a sort of extra that if it's not possible to present it before the indictment, then if it's in the interest of the child, the child can also be charged in the absence of an individual assessment. And that can also be of benefit of the child sometimes, for example, in order to ensure a speedy processing of a case, and that it is not, the child should not wait very long before an individual assessment is taken and knows more about whether a case will be held against him or not. And also in cases of diversion, for example, sometimes it's important also to make a quick decision and then afterwards also assess what the individual needs of the child are. It is also stated that updates should be provided by professionals throughout the proceedings, because sometimes criminal proceedings can be very lengthy. And then it's, of course, the circumstances of the child can change. And in many countries, preliminary measures are also something common. So that, for example, probation supervision has already taken place, or a child is placed in a form of an institution, for example, or training school. And then it's of importance to also report about the progress that the child is making to the judge in order to make a fair decision with regard to the disposition. Then how should it be undertaken? The directive gives some guidelines on this, but not too many, because it will also give states the opportunity to implement their own way of individual assessment. And that's also why it's important that these kind of projects exist and are taking place to research how this is already done in practice and how it can be improved. First of all, it is important that the child is closely involved in the individual assessment. And I think that's also in line with the idea of the right to be heard, as you can find in the CRC, so that all decisions that are taken in the life of a child should be, the child should have had the opportunity to give his or her views on that. It should also be carried out by qualified personnel. And using again this multidisciplinary approach. Also, for example, maybe sometimes at the police stage, police officers may conduct individual assessments. But that will mean that they also need some training on that, on how to do that, on what kind of questions to ask, and how to have a child-friendly conversation also with the young person. And of course, for social workers and people who are trained more in working with children, or psychologists, this is more self-evident, but not so much for all the legal professionals. And of course, it is also important that a parent or someone else who is the legal guardian of the child is also involved to provide information during the individual assessment, and also to support the child and to know what will happen and what the procedures will be. Then I think Ruta also said a little bit about this already, what the purpose and the goals are of individual assessment. And I think in a lot of countries, when this already happens, there's some kind of functional goal to individual assessment, because it's something that needs to be done in light of a criminal proceeding where you don't want the young person to commit offenses further. So you see that individual assessments are taking place to assess the risk for reoffending, and then on the basis of that risk also see what kind of disposition or measure or sentence is needed in order to help the child not to reoffend, and to in that way also protect society and the victims. But I think you can also see it in a broader way, this right to individual assessment, because it does not have to have only this more instrumental goal in the proceeding, but it can also help, for example, in informing children about the procedures, about the rights that they have in the procedures, and also to explain what the role is of this assessment in the final decision making that is done by a judge, for example. And social workers can have a role in that as well. In when they have information and know about the procedure, they can also explain it to the child and to parents. Of course, as I said, it's important to understand the situation of the child, his or her family, social, emotional background, to see whether specific treatments are needed to help the child and to support him or her in his or her needs. The risk assessment aspect, and I will say a little bit more about that in the context of the Netherlands as well. And another goal could also be to see if this child has specific vulnerabilities that need adaptations in the justice system. For example, whether the child understands everything properly, when it is very young, whether there are specific adaptations needed in the courtroom to support this young child that is accused of a crime. Or children who have, for example, specific language disorders, or have difficulty speaking to adults or to others. And if that is needed already, that information can be given to the judge, for example, or the prosecutor, and some attention can be given to that so that they can adapt the proceedings to the individual needs of the child more procedurally, and not so much based on what the outcome will be of the procedure. And of course, again, vulnerable groups of children, children who, for example, have learning difficulties, or children from ethnic minority backgrounds, need to be given attention in there as well, because they may need other information, and they need to be extra help maybe to go through these kind of procedures. Then looking at what kind of practices already exist. Of course, because I'm from the Netherlands, I know more about the Dutch practice. As I said before, in the Netherlands, we already used before the implementation of the directive a structured assessment tool since a long time already. In the Netherlands, the Child Care and Protection Board is also responsible for doing these assessments. So they have, on the one hand, the task to do research in cases of child abuse, for example, and child neglect, but also they do research in juvenile criminal cases. Recently, a couple of years ago, they also broadened this instrument that they used. So that means that already at the level of the police, a first individual assessment is undertaken, mainly based on static factors such as the gender of the young person and whether he has had prior contacts with the police. But to make a quick assessment of this young person and to see, okay, what kind of measures should be suitable, what kind of route could we take. And then the Child Protection Board will do a more extensive assessment later in the proceedings, in which they use a structured list and they have to fill in all the lists. They also talk to parents, fill in that survey as well. Then a sort of a risk assessment is coming out of that, which also can be linked then to types of measures that are preferred then. Something new, what they introduced recently is that they also provide the child and the young person, when the report is finished, to send them a child letter, as they call it. So they send a child-friendly summary in clear and plain language to the child and the parents, so that they know, okay, this is the outcome of the assessment, and this is the advice that the Child Protection Board gives to the judge on what kind of measure or sentence they think is most appropriate. So I think that is very important, that young persons are not only involved in the assessment as the subjects to be heard, but also that they are given feedback on what the outcome is in an understandable way for them. I also would like to highlight the example from Belgium, because in Belgium the social service is very much connected to the youth courts. Because the social workers work basically for the court only, and they prepare advices and assessments for judges, and they work closely together also in cases with judges. In Belgium, there's also this tendency also to start with provisional measures quite early. So that a reaction or a sort of a support program can be started quite quickly, in which young persons are given support by probation services. And then later on, the judge can base his decision on what the young person is doing during that provisional period, and if the young person is working towards his reintegration and abiding by the rules also. And in Belgium, there's also a strong focus on restorative justice measures, where they would like to involve also, of course, the victims and society in how to restore possible damage and the relationships in the community. But on the other hand, in Belgium, there's no standard report as there is in the Netherlands, where it's very structured and, okay, you know what kind of questions to ask and what kind of things to assess, but that's more open in this Belgian practice. One other thing I would like to highlight is I think that's important also that several stakeholders cooperate in cases. And you see that also more often happening nowadays, where there are more meetings with, for example, already the prosecutor, police, social work, to see what is needed for this young person and what would be the best route out of the criminal justice system and towards a law-abiding life in the end. So I think that's important that there's cooperation. and that individual assessment is also a part of that cooperation, not only looking at the legal aspects of it, but very much on the individual circumstances of the child in the family. I think this is what I wanted to share with you today. I look forward to any questions that you may have. Please let me know. And I also look forward to the coming presentations. Thank you.
Oh, well, thank you to you, Stephanie, for that very succinct run through all the way from 1985 and the Beijing rules up to today, and how we're coping with Directive 2016-800 and pointing out what you're up to in the Netherlands. I really did like your emphasis on child and brain development and how important maturity is in working with young people and keeping them and their parents closely involved in the process of independent assessment and what is going to happen next in the life of their child. So thank you very much, Stephanie.
Thank you.
And thank you for keeping to time too. I see there's a poll come up, which is what I'm hesitating about. I imagine everyone has had that polling. So I now turn to Silvia Rucevic, who is a psychologist and an academic working at the Strossmayer University in Croatia. And very pertinent for us today, Silvia has worked in a juvenile probation hall as a psychologist, and she has been responsible for psychological assessment and supervision and treatment of minors. And Silvia today is going to talk to us about the problem of risk assessment of children and how can we better make a prognosis of what is happening in a child's life in order to reduce their involvement with the criminal justice system. So Silvia,
thank you.
Over to you.
Okay. Statistical data and longitudinal studies show that there is always a small group of children and youth who are actually responsible for the majority of criminal acts, and they also tend to reoffend repeatedly and frequently. And given this, it has become one of the most important questions. Can we beforehand decide who belongs to this high-risk group and who does not? And I guess this question has become an important part of criminal policy, especially when it comes to early interventions and preventions. However, predicting probability of children reoffending or returning to justice system is one of the most challenging tasks for experts. And hopefully I will tell you why it is really challenging. Okay. When it comes to reoffending in children and youth, we don't have actually any data from Croatia, but studies from United Kingdom, United States, Germany, Australia, New Zealand show us that actually reoffending rates when it comes to children and youth are higher compared to adult reoffenders. Also, it has been shown that reoffending rates for young adults have followed a general downward trend for the past 10 years. By contrast, reoffending rates for children have been generally increasing. And these findings show us that a lot of children end up in a destructive cycle of crime, which they actually have problems of getting out of. Also, number of studies, and you who work in practice and actually deal every day with children who offend and reoffend, know that many of them have experienced traumas, more than 60%, including abuse and bereavement. Almost half of them have grown up in social care. Most of them have been excluded from schools, which means that at the end of the day, they don't have any vocational skills which could provide money for basic living. Also, about a third of them have experienced some substance-related dependencies. Some of them have mental health problems, personality disorders, even problems with intellectual functioning. Also, almost half of them have a parent or a sibling with a history of imprisonment. Also, young people are getting increasingly isolated from families. Some young offenders actually end up in custody a long way from home. The idea behind this is to send the child away from problematic neighborhood, problematic family. On the other hand, these children usually don't have means, financial means, nor their families have financial means to come and visit, which means that some of them actually spend prolonged times in institutions without any contact with their family members. Also, young offenders usually lack adequate support. Juvenile justice systems are under strain. I guess in Croatia, I guess it's everywhere in Europe. We usually have staff shortages, staff burnout, damaged infrastructure, no money, so you can't provide certain services. And also there are high needs of young people. As a result, a lot of young people don't actually make positive relationships with people who are supposed to work with them, with experts. And as you know, attachment to either a parent or other responsible adult is one of the greatest protective factors against reoffending and offending in future. Also, youth do not get enough professional support. They don't know what their future holds. As I said, most of them are expelled from schools, and as a result, they don't have a vocational skill. They feel unsettled, anxious, bored, and usually angry. And unfortunately, there are some young people who fall unsupported through the system's cracks once they switch from youth system to adult systems, or actually go to prison for adults. Okay, before I actually turn to risk assessment among children, I will first focus on adults. Why? Because there are so many problems when it comes to risk assessments among adult offenders, and these problems are even more exacerbated when it comes to children and adolescents. When it comes to adults, there are a lot of assessment tools available. More are available in United States, less in Europe, because if you want to use it, you have to translate it. Some of these assessment tools are not culturally appropriate for certain European countries. So basically, when you come from Europe, number of available assessment tools becomes limited, or some countries actually develop their own for their needs. There are usually two approaches when we talk about risk prediction. Anglo-American countries usually tend to base their crime forecast primarily on these assessment tools. However, European countries usually have more comprehensive approach, which means that they use different risk assessment tools, but they also consider that these tools are not sufficient enough for crime prognosis, which means that these tools are usually accompanied by other carefully and clinically informed appraisals. And these tools cannot actually substitute these comprehensive appraisals. Although European countries prefer comprehensive appraisals, several studies done in Germany have shown that quality of clinical reports, which are later forwarded to judges, prosecutors, etc., actually vary in quality in great deal. Some of them actually lack crucial information on, let's say, previous mental health problems in children, adolescents, or adults. Some of them lack information on IQ. Some of them lack information on social support. So although we in Europe like comprehensive approach, there is a great difference in quality of reports which are used later to make decisions for offender. Okay, when it comes to risk assessment tools, I like to say that they are usually taken out of context, which means that they usually focus only on one part of a person's life. And they usually somehow ignore demographic characteristics, criminal history, or personality variables, which means they are not sufficient to predict individuals' behavior. And for example, yes, person can score high on a certain risk assessment tool. However, usually what we like to examine are certain protective factors which could actually ameliorate this risk. Also, there is a strong emphasis on historical events. Yes, past behavior is the best predictor of future behavior, but our circumstances change. This change can actually directly influence future behavior of a person. Also, there is a question of predictive validity of all risk assessment tools. I haven't found, well, there are not many studies which have actually examined how long or how good are these assessment tools in predicting future offending. If they have studied predictive validity, follow-up periods were usually short, 1 or 2 years. However, the question remains, what happens to a person 3, 4, 10 years from the initial assessment? And this is what it's supposed, well, this is the main question for a criminal justice system. And finally, a lot of assessment tools neglect individual developments and change, which brings, well, the question, what about children and adolescents? Okay, before I actually continue, I will now give you an example of one multidimensional personality construct, which has been extensively studied for the past 15 to 20 years, first in adult offenders, then in adolescents and children. This personality construct was once deemed as one of the best or the strongest predictor of future offending and reoffending, especially violent, and hallmark of extremely dangerous individuals. It has been incorporated in many risk assessments, not just in the United States, but also in Europe. And certain features have been also introduced and included in both the DSM-5 and ICD-11. You may ask, why am I talking about this construct? Because despite all of this I have said previously, there are so many issues with this personality construct, which unfortunately can greatly influence decisions we make about not just adults, but also adolescents and children. And I will be actually talking about psychopathic traits. First, we will start with adults, because this is the construct which have been primarily developed on adult offenders. There are several risk assessment tools for psychopathy. One of the most frequently used is Psychopathy Checklist Revised. It is used in Europe, and there are several countries which have translated it and actually use it as a part of risk assessment for offenders. Just so when I will be talking about different studies, you know what psychopathy is. It is usually, it comprises several dimensions. Affective deficits and interpersonal deficits, they're usually called factor 1 when it comes to Psychopathy Checklist Revised. Affective deficits are usually shallow affect, lack of empathy, guilt, or remorse, and interpersonal deficits are egocentricity and manipulation. Factor 2 or behavioral deficits usually encompass impulsivity, irresponsibility, and rage of unethical and antisocial behaviors, including criminal. And early studies have actually found that this psychopathy risk assessment tool is correlated with various negative life outcomes, including poor institutional adjustment, community violence, and criminal recidivism. Also, a number of studies have found that psychopathy alone may predict these negative outcomes, as well as more elaborate risk assessment tools. When you see these results, it makes sense why psychopathy has become part of risk assessment in many European countries. However, newer studies show that predictive validity of psychopathy checklist and psychopathy as a construct is not as good as previously thought. For example, this is one longitudinal study, and it has shown basically that after 2 years, factor 2 behavioral personality features basically marginally predicted violent and general recidivism, whereas affective and interpersonal deficits were not related to future violent reoffending. You may now ask what happened. The thing is that newer studies are now examining predictive validity of psychopathy after controlling for a number of confounding variables, including level of education, criminal history, hospitalization, imprisonment periods, IQ, and risk assessment scores. And once you control for or take into account all of these variables, psychopathy is not a strong predictor of future offending and reoffending. For example, it has been shown that psychopathy score is positively related to longer imprisonment periods. I think it's, well, it sounds logical because if you're in prison, well, if you're in prison for a long time, basically you try to regulate your emotions and become less emotional so you can cope with everyday life. Okay, since psychopathy seemed so great and so strong predictor in adults, scientists and practitioners decided that they should do a downward extension to adolescents. And psychopathy checklist youth version was developed for adolescents. And again, it has been shown that indeed, psychopathy checklist youth version is related to both general and violent recidivism. However, this relationship is based mainly on behavior psychopathy features. Those are impulsivity and irresponsibility. And if you have ever read any of longitudinal studies, such as Dunedin longitudinal study, Cambridge longitudinal study, Pittsburgh, impulsivity is one of the strongest and one of the most robust predictors of future offending. So basically, psychopathy checklist in youth doesn't have any, is not a better predictor than some other already existing assessment tools. Again, it was only a short follow-up period, over a year. And also studies have shown that aging process alone ameliorates psychopathy symptoms for a significant proportion of youth, meaning that psychopathy assessment would actually lack sensitivity for longer term predictions. Despite this, there are, again, a number of studies examining psychopathy in adolescents. And then they've tried to extend this construct to girls, to female offenders. And what they have found was that although psychopathy is a good predictor, or at least mediocre predictor for males, for girls is not a such good predictor, or cannot be used in risk assessment when it comes to female offenders. Again, even if there are correlations between psychopathy and different types of recidivism, most of it can be, is related to behavior features of psychopathy. And it seems that psychopathy checklist and psychopathy as a risk factor is not well suited for girl offenders. Also, a number of studies have shown that these interpersonal and affective features of psychopathy are not stable across adolescents. Meaning that, yes, at one point you can have a young person high on callous and unemotional affect. However, through different interventions, this level can be, will decrease. And finally, there is one longitudinal study which has followed, which has examined predictive validity of psychopathy checklist youth version after 10 years. After 10 years, neither total scores nor factor scores predicted general or violent reconvictions. Okay, despite this, there are several attempts to actually examine incremental validity of psychopathy checklist. Why is it important? Because there are, these studies are lacking. As I said, different countries use different risk assessments. They usually don't examine predictive validity. We don't know how good are they at predicting future behavior. Second, we don't know if any of these risk assessment tools give any new information above some other already existing. Okay, so let's see what is happening. Only 4 studies have been done, although it is a really important question. And there are really unequivocal results. Well, results are not consistent. Some studies show that there is identical predictive accuracy of psychopathy checklist, youth version, and some other risk assessment tools. Some others show that psychopathy checklist is worse in predicting future reoffending. Some of them show that it's better. So basically, we have no idea how good psychopathy checklist is in predicting future offending and reoffending. Although you've seen we have lots of problems with psychopathy as a construct in adults, also in adolescents, again, scientists and practitioners decided that we should study psychopathy in children. And what has been suggested that callous and unemotional traits, which are affective deficits, alone are likely to differentiate a more severe and aggressive subgroup of youth who have elevated risk of future problem behaviors, poor life outcomes, including adult psychopathy. Number of studies have been done, and although there are lots of methodological issues with these studies, it was quite compelling. So the DSM-5 and ICD-11 has actually added CU-based specifier, which is called limited prosocial emotions. Again, lots of problems with studies. Previous studies have usually not examined or controlled for early conduct problems, individual characteristics like hyperactivity, impulsiveness, or family risk factors, including inadequate parenting practices. Also, studies which have been used as a proof to get this CU specifier into the DSM-5 and ICD-11 have usually oversampled high-risk children and youth who also exhibit high levels of impulsive behavior and attention deficit hyperactivity disorder. Again, number of longitudinal studies have shown that impulsivity is one of the strongest and most robust predictors of future antisocial behavior, even 20, 30 years later. And finally, there are some newer studies which actually examine predictive validity of this CU specifier, and they have shown that once it is included in risk assessment, after controlling for other risk factors, it actually has restricted clinical usefulness. Another study with younger children have shown that after controlling for previous conduct problems, hyperactivity, negative parenting practices, callous and unemotional traits are not predictive of future offending or future aggressive behavior. Only impulsivity, need for stimulation was related. And again, this has been shown previously in a number of longitudinal studies. Okay, overall, when it comes to risk prediction in children and adolescents, usually studies who are supposed to examine reliability and validity of all the assessment tools usually have short follow-up periods. These studies are lacking. I haven't found a lot of them. Also, some of risk measures are direct downward extension of adult measures. So the question is, how applicable are they to children and youth? And usually there is no information on incremental validity of different risk assessment measures. As I have been listening to previous presentation, yes, different countries have different risk assessment tools, but we actually have no idea how good they are. No, they have been competed against some other well-established risk assessment tools. Why is this a problem? Well, finally, we have the question, can better prognosis reduce reoffending and returning to criminal justice system? Well, I would say no, but yes. Which means that we need to use holistic approach. It has been already mentioned in previous presentation. When doing risk assessment, what is needed is balanced evaluation of strengths and weaknesses. This would be the most accurate assessment of violence, of risk for violence. Given this, it is possible to give personalized guidelines for a strength-based case management. And of course, we will have an effective mitigation of recidivism risk. For example, let's say that you have a child high on callous and unemotional traits, or a fledgling psychopath, if you would like. I think the most experts and practitioners, what would they do is that they would take this child away from family. Especially family has a history of imprisonment, history of criminal behavior. And this child would probably, would likely end up in some kind of institution because he is a potential risk because of his personality traits. But that would be the worst solution for this child, because number of studies, longitudinal studies have shown that if you want to buffer callous and child against this genetic vulnerability, or if you want to ameliorate callous and unemotional traits, children should be brought up in warm families, families with positive parenting practices, caring families. So instead of sending this child to institution, better solution would be to find a good foster family who has been educated how to deal with children who have certain affective deficits. And basically, in conclusion, if we want to have a better prognosis, we need to implement evidence-based practices and policies, which means that we need to use valid and reliable instruments. Again, as I said, a lot of countries are developing their own, but development is only one stage of whether it should be used in the future. Second, in addition to risk measures based on longitudinal studies, assessment should include age when the first delinquent act was committed, problems at school or work, antisocial peers, poor use of leisure time, lack of parental supervision, harsh parenting, criminality in family members, and plus capabilities and strengths. Although risk assessments usually contain this information, what often happens is that there is no, I would say, holistic approach in understanding what interaction between different risk and protective factors means. So in future, people who are in charge of risk assessment should actually be informed, or should be informed on life force criminology theories, which have been studying this dynamic interaction between positive, protective and risk factors. And after considering these interactions and understanding how one factor actually influences the other, we will get the best risk assessment, and I would say the best prevention and intervention for a child or a young person. Okay, this is it from me.
Thank you very much, Sylvia, for that illuminating talk. I have never been present when someone has dissembled the psychopathy as academically as you have done it today. And I thoroughly enjoyed everything you had to say. I think that coming back to what you said at the very end chimes with what it has always been thought, in that you think, what is it about young offenders? It's home, it's school, it's friends, it's their community. And as you have just said, for valid and reliable assessments, that sort of background needs to be examined very carefully. I thank you very much. I'm sure that everyone will be downloading your slides as quickly as possible. Thank you, Sylvia. And that we're very, very pleased to have Tor Anderson with us today. He is a psychologist working at the Norwegian Directorate for Children, Youth and Family Affairs, and he is noted for his work on cognitive behavior and a residential treatment model called Multi-Funk, about which he will talk today. Thank you, Tor. Over to you.
Thank you. My title is The Use of Risk Assessment in Multi-Funk for Treatment Planning and for Placement Decisions in General in Norway. But I try to change. Yeah, I'd like to start with this picture. But first, is it possibly that I don't see all of you because some of my text is hidden for me?
Yes, that's because our pictures are hiding it.
Yes.
I can't do anything about that, okay. But Thomas might be able to remove all of us.
I want to cite Mark Lipsey, one of, I think, the biggest researchers in this topic, from his article in 2010. He says that we now have research on best practices for juvenile justice involvement youth and the policies that support the practices. We find this reflected in the increased use of evidence-based practices and programs, in the growth of science of risk and protective factors and criminogenic factors, and in the development and use of validated risk and needs assessment instruments. We have learned about the importance of advancing our work on an ecological platform, serving youth closer to home and better connecting to family, school, community, and pro-social peers, while utilizing strength-based approach. And the important, I think, is the last sentence. The true challenge is not, therefore, a lack of knowledge of what works, but rather is in translating the robust body of knowledge into practice. We did a comprehensive review of research in 2003, where we thought, when we started, we have to do the review of research to conclude that we need more research. That was not true. There was so much research out there, you only had to put it together. The real challenge is putting it into practice. Traditionally in Norway, I work within social welfare and with institutions. We have had so-called general institutions. That means that we have placed youth with different problems and needs in the same institutions. Children with behavior problems, criminal behavior, substance abuse problems, and other needs have traditionally been placed together in the same institutions. But today, it's not so in Norway. The situation in Norway today is that we have divided all institutions within social welfare for youth to be specialized for different target groups. We have some institutions for high-risk criminal juveniles, other institutions for low-risk criminal juveniles, other again for substance abuse users, and other institutions for those who doesn't have such problems. This is seen as a harm reduction through less negative peer influence by separating the groups, less deviant training. To make this possible, we have established a national team to assess all youth with serious conduct problems before placement. We have one national team. All juveniles that have been placed in institutions are assessed by this team. And they are doing risk assessment with youth level of service, case management, inventory, and this is done by psychologists. And then we do a new risk assessment at discharge from institutions and make an outcome measure for all youth to see if we have succeeded not only in changing behavior, but also in changing risk level. This is based on conclusions from research. You should not mix high and low risk offenders in the same treatment program, because this is a risk for low risk youth. High-risk youth have many risk factors, while low-risk youth have fewer risk factors. And then you may increase risk factors for low-risk youth if you place them together. Treatment should also target change of the risk factors that maintain negative behavior. This means that regardless whether treatment is performed within institutions or outside, the treatment should focus on the individual youth, the family, the peers, the school, and leisure time. And these are the major risk factors based on research. This is from Don Andrews' famous book and research on the psychology of criminal conduct. He talks about the central 8 risk factors and the big 4 risk factors. The big 4 predicts better than the central 8. It's about history of antisocial behavior, which is a strong risk factor, a predictive factor, but it is also about antisocial personality pattern, antisocial cognition, antisocial associates, family factors, and school and work factors, but also about leisure and or recreation and substance abuse. We use these risk assessment tools, youth level of service, case management inventory, which is a 42 items instrument designed to measure risk, need, and responsivity factors in adolescents who have contact with the justice system. And when it stands risk, need, and responsivity factors, that means it does not only measure risk, it also measures need, the individual juvenile needs, but also the family needs, the leisure times needs, and the peers needs. And responsivity factors. That means all other factors that may influence the treatment, other than risk factors. Cognitive function, depression, anything else. And these teams, assessment teams, makes a report that describes the risk factors, the need, and also other factors that is important to influence the treatment. The instrument has been validated for use with both males and females between the age of 12 and 17 in many countries. In Norway, it's not normed or validated yet, so we use it carefully. But there is no ongoing big study to norm the instrument in Norway. This is the risk domains in youth level of service. It's eight topics, prior and current offenses. There is 5 items in the instrument. It is family circumstances and parenting, 6 items. And it's education, 7 items, peer relations, 4 items, substance abuse items, 5 items, leisure, 3 items, personality and behavior, 7 items, attitudes and orientation, 5 items. So it is not only about the youth, it is the ecology of the youth. Its possibly total score is 42 items, but that we have never seen. The cutoff between low and high risk is about 22, 23 items, or scores. This is the problems with assessment. The team, national assessment team, should try to separate the high risk and the low risk youth. It's easy, those who score 10 to 15 on the risk instrument, it's easy, they are low risk. It's also easy, those who score 27, 28, 29, that's easy to conclude. They are high risk. The problem is those in the borderline, those between 18 and 25. It's difficult to define correct target group and risk level for youth between scores 18 to 25. They have similar needs, and it's therefore difficult to decide if placement will reduce or increase the risk. Because that's the target for our work, is to separate them so that we don't place low-risk youth juveniles together with high-risk juveniles. We don't place serious substance abusers. No, we don't place those who use drugs sometimes together with serious substance abusers. And we don't want to place those who do criminal behavior once a year together with high-risk criminals who do it all the time. So therefore, we always have to do a clinical total assessment about what will be the best for this individual youth. To do this, we have a quality assurance systems. Every month, the team, the psychologists in the team, scores the same case. And then we compare the results. Every month, we have individual scores on the same case and comparison and discussions. Sometimes we come together and sit in the same room and scores the same case. Discussion every item. Other times we score the same case at home and we meet and see the results and discuss. Why did you score that item? Why did you not score that item? And we have discussions both about the different items and discussions of target group and then placement decisions. This we have done since 2013. So this is good implemented by now. When we started, we tried to train the social workers to do this. And we waited a year and then we tried to compare how they scored and which decision they made. And it was so different, it wasn't possible to make sense of it. So we concluded that this had to be done by trained psychologists, and that we do now. So now we have a differentiated institutions in Norway, and we have trained psychologists who assess them. The assessment is made only based on papers, documentation. They do not speak with the juvenile, they do not speak with the family. They only use documentation, written documentation. But we have made a separate paper, information paper, based on youth level service, where we ask a lot of questions. This we send out to the municipalities in advance, and they have to speak with the family, the juvenile, the school, those who have information, and write it down in this paper and send it to the assessment team. If we lack some information, we ask for it, so that we are most ensured that this is correct. We also ask specifically, what do the juvenile think, him or herself? So we ensure that we got the information from the juvenile too. This was a little about how we use youth level service for decision making. The next step is how we use the instrument for treatment planning in multifunc residential treatment model. Multifunc or multifunctional treatment in community and residential settings, for short multifunc, is a residential treatment model developed in Norway and Sweden based on a comprehensive review of the research. The review is published in a book in about 500 pages in Norwegian and Swedish. This was a project initiated by the Norwegian department. And the first step was to make this review of research. When the book was published, we got the department asked us to produce a treatment model based on the research. How should a treatment model based on the research for high-risk youth look like? And we used some time to make manuals written description of how could you translate the research into a practice model. The model targets high-risk juveniles with conduct problems and criminal behavior, and it combines residential treatment and aftercare in community settings. When we had translated it to the research to a written model, we had to implement it in practice. So we implemented it in Norway, Sweden, and Denmark. And I think today the problem is not lack of research. It's not a lack of how treatment should look like. The real problem is how to translate it into practice, how to make the staff follow the model. We have succeeded in some institutions, we have not succeeded in other, and we see even those we have succeeded with, it changes over time. To make institutions work perfectly is difficult. And it is an ever ongoing process. We had one institution that worked good for 10 years and suddenly it broke down. They got too many serious criminal and violent youth at the same time. That makes things with institutions. It breaks down and then it takes a long time to build it up again. So this, I think, is the real problems. It's implementing issue. This is how the treatment process in Multifunc looks like. It consists of two main phases. One is the institutional phase, and the other is the reintegration or aftercare. This last reintegration and aftercare happens in community, not in institution. The institutional phase are divided in three parts. The intake phase, with focus on motivation, assessment, structure, high level of structure. Then they go over to the treatment phase, continued motivation focus, but also focused treatment, and focus on establishing a good treatment climate. We see that one thing is to have a good model. Another thing is to have good staff. How the staff behave is very important. When you have institutions with 20, 30 staff members, it's difficult to make them work together. I've seen good and bad examples on this. We had, for example, one juvenile. One of the staff members had put his car keys on the table and left it. And the juvenile found the keys and he couldn't stop it. He took the keys and he and two other juveniles escaped with the car. When they was brought back by the police, I was at the institutions. And I looked at the staff member who had forgotten the keys. He came, it was summer, he came with the youth, sat down out in the garden to talk with him. And he started to say, I'm sorry that I put you in this risk to steal the keys. He took the blame for the situation, but then he continued. But this risk you may meet some other time. How could you resist it then? That I think was a good example on a good milieu therapist. He didn't blame the youth. He took the responsibility. But this is difficult, and this is beyond the guidelines from research. Then when it comes to close to transition, they should prepare re-entry. The juveniles are visiting their family during the whole treatment process, but in the transition phase, they should stay more and more at home to train to be outside institutions. And then they move home, and we start with the reintegration or aftercare phase. This is family support. I'm not going into details in the treatment methods because this is more about assessment. The duration of residential stays is about 6 months. And the duration of aftercare is about 4 to 5 months. So about 1 year treatment together. But this is not fixed. When they have been in institutions 4 or 5 months, the psychologists in the institutions do a new risk assessment and look on which factors have we succeeded in changing and which have we not. Then they have to decide, should this juvenile stay in institution 1 month more with focus on the risk factors we have not succeeded with, or should some other instances take care of that after the juvenile have moved. The same when the aftercare phase is finished, then they do a new risk assessment and look how many risk factors are there left. Should we continue 1 or 2 months more, or is there other instances in the community that should work on this? Focus on treatment during the whole treatment program is focused on risk factors within the juvenile, within school, within peers, and within family. And we have organized the institutions with 4 teams. We have one milieu team, milieu therapist, those who work with the juveniles daily. We have 1 school teams who focus only on school. They work with the juvenile regarding school, but also with the teachers. And we have 1 family team who are trained family therapists. They are trained multi-systemic therapists and work with the family during the institutional phase and during the aftercare. And we have family apartments in these institutions. So the family therapists work with the families at home, but also with the parents at the institutions. The parents could visit the institutions, stay in the family apartments together with their child and train. And we have 1 assessment team consisting of psychologists on each institutions. They could assess the juveniles, but they could also guide the staff. And we have case planning. And case planning and intervention should be linked to assessment. Edward Lattessa, American researcher, he says that assessment is an engine for treatment. It should guide treatment all the way. And areas where a problem is identified should be addressed with some intervention activities. If there is no problem, no action is required. But at the same time, we see when we start the assessment, we start the treatment, we identify the problems on several topics, and we plan interventions on all those areas. But you have to follow up also the topics where there is no problems, because there could be a problem during the treatment. And we do treatment planning based on the youth level of service case management inventory. The multifunc institutions target high-risk youth, and that means that they have many risk factors. All the juveniles in the multifunc institutions have more than 22, 23 risk factors. Some of them have up to 30. That means we have to have treatment targets on many factors. And that makes this work very complex. The National Assessment Team have made an assessment based on youth level of service before placement. that the psychologists in Multifunc do a new assessment based on youth level of service when the juvenile arrives. And then they can speak to the youth himself and also the parents. And we see that this may change the total score 7 points. But they then involve the juvenile and the parents, and they could hear what they think about the same factors. And also discuss with the parents and the juvenile, what do they want for the future? What do they want from the treatment? They seek to get agreement with the juvenile and the parents. What should we try to succeed with in this treatment plan? And based on this, the psychologists in Multifunc developed treatment plans with goals that later will be evaluated. They developed treatment plans who describe when you are finished here in this treatment program, when you are finished also with the aftercare, how should the world look like for you then? And before leaving the youth, before ending the treatment program, they do a new assessment to see how is the situation. Is the situation like that we planned in the beginning? The problems assessed with youth level of service are made into change target goals for the whole treatment period. So if we assess the problem with the youth level of service, we try to change it to a treatment target. When we started this national assessment team, and we started with writing reports of what is problems for this youth and his or her family. And this was sent out to all institutions who took care of criminal juveniles. We thought that this would be translated into goals. After 2 years, we went out to see if that happened, and it did not happen. The traditional institutions took their report and did nothing with it. They was more occupied by the behavior of the youth than the risk factors. In Multifunc, they are not allowed to oversee the risk factors. We have weekly consultations and quality assurance with the Multifunc institutions. Every week, they have to put out papers, documentation. What was this week's goal? If we did not succeed in this goal, what was the barriers? And they have to do analysis, either functional analysis or multisystemic analysis, to see what was the barrier to succeed in reaching this goal this week. And we have discussions, phone discussions, consultations every week. The problems assessed with youth level of service are made to change targets goals for the whole treatment period, about 1 year. But in addition, there are weekly targets, and the psychologists have to ensure that these are in accordance with the long-term goals. Because we see that the milieu therapy, the milieu staff, they easily change focus to make the youth behave within the institution and forget the ecology and the risk factors outside the institution. So therefore, we have decided that the psychologists within the institutions have to control the weekly goals for the juveniles, for each juveniles. Control. Why have you this goal this week? Is this based on an analysis, and is it in accordance with the long-term goals? And we also have a rule that says the goal is not to make the juvenile behave within the institution. The goal is to have the juvenile behave outside institutions. We have seen examples where the juveniles is violent, acting out within institutions. but functions very well in school and at home on leave outside institutions. Then we say it's time to move out, because a lot of acting out behavior within institutions is a result of being in institutions and being together with other juveniles with the same behavior. In addition to weekly evaluations, we also have monthly evaluations to see, do we succeed over time? To not only see, is there succeed this week, but what about 4 weeks together? Sometimes we see that they could succeed 1 week, but not next week, going to school, for example. Other times you can see that they succeed not the first week, but the second, third, and fourth. And then we are on the right way. So we have to assess all the time, how is this working? And here is based on Don Andrews in Canada, from his book, Psychology of Criminal Context, Major Risk and Need Factors and Promising Intermediate Targets for Reducing Recidivism. They often have a history of antisocial behavior that we have to know something about. And that means that the need is to build non-criminal alternative behaviors in risky situations. They often have an antisocial personality. That means we have to build problem-solving, self-management, anger management, and coping skills. They often have antisocial cognition, attitudes, values, beliefs that supports crime, and so on. That means that we have to reduce antisocial cognition, recognize risky thinking and feelings. We have to build up alternative, less risky thinking and feelings, and adopt a reform and/or anti-criminal identity. And this is difficult. The high-risk juveniles very often have started very early. They have built a strong antisocial cognition. This is not easy to change. I had once a presentation in Norway for Red Cross in Oslo, where we were 4 presentations, and there were 3 adult criminals who take part of on the conference, and we had a panel debate afterwards. The 3 adult criminals and the 4 researchers. And I asked one of them. He was 33 years old, and he had spent half his life in prison for very serious criminality. And I asked him, where did it start? It became quiet for a while, and then he answered, it started in the kindergarten. It started when I was 5-6 years. I was a very active child, a problem child. And the staff in the kindergarten controlled me all the time, and the other children avoided me. So he said, then it continued in the school, in the children's school, and then further on. I was not included, and I sought other children and juveniles who neither was included. I think it's right. It's much about not to be included, to be outside. Some years ago, when my boy was in kindergarten, 5 years old, we should have a birthday party. It was usually at our place that then we invited all the boys, and we did so. And one of the boys was like this adult criminal, but he was 5 years old. He was acting out all the time. So the birthday party for us was very tough. We ran after the boy all the time. Sorry, all the time to control him. Next year, when we should have this birthday party, we was thinking, should we invite this boy? We could have a calm, normal birthday party or a tough birthday party. We solved it by celebrating the birthday party at a place where it was allowed to act out. Big place with, I don't know what it's called in English, but you could be wild. It was okay. And it worked fine. But for me, afterwards, it was a question thinking about, even by us, we thought about excluding this boy. And that, I think, is the important part of the process. They are excluded. And even we made those thoughts. Then if we had not invited this boy, we have excluded him. We have made him to a boy who are not invited in birthday parties. And we have made his parents to parents of the boy who are not invited. So this was important thinking. We are all a part of securing these childs. It's not for nothing the word, it's take a village to raise a child. It's not only the parents. But also a major risk factor is the antisocial associates. We have to work with reducing association with criminals and enhance association with pro-social people. That is also difficult. Many of these juveniles are known for their acting out behavior, their substance abuse behavior, their criminal behavior. If my boy came home from school and told me that he had met a boy from an institution with substance abuse problems, I wouldn't like him to have contact with him. But they need this contact. But they have a bad reputation. And this work is important because they are influenced more by peers than by adults. And we had one example in my home place, Bodø, a family with a substance abuse son on 15 years old. And they got multi-systemic therapy. And they were interviewed in the newspaper afterwards and asked, what was the main factors that you succeeded? They answered it was that multi-systemic therapy, MST, established a contact with the police. So every time our boy at 15 years old ran away, the police, we found one special person within the police, and they went out looking for him. And they found him and they brought him home. Two things happened. The boy knew that every time I ran away, the police will come and get me. But the most important was that the substance abuse milieu in Bodø learned an important thing. They learned that every time that boy comes, the police comes 5 minutes later. So they avoided him. They told him, keep away from us, because when you come, the police also come. But also these factors are important, the family factors. Key elements are caring, better monitoring, and/or supervision. We have to reduce conflicts within the family to build positive relationships, better communication, enhance monitoring and supervision. All these factors are factors that are assessed with youth level of service case management inventory. And we have to focus on school or work. They often have low levels of performance and certification in school. We have to work with enhanced performance, rewards, and certification. But also leisure and recreation. They often have low levels of involvement and certification in anti-criminal leisure activities. And then we have to enhance involvement and certification in pro-social activities. And substance abuse is an important risk factor. So we have to reduce substance abuse, reduce the personal and interpersonal supports for substance abuse behavior, and enhance alternatives to substance abuse. All this you find in the book from Don Andrews in 2006, and it's updated in the newest, is the 6th edition published in 2010. The Criminal of Psychology Conduct. It's a very good book. Sorry to say, Don Andrews, I met him several times, and he's the only man, the only researcher I know in the world who could use 6 hours and present in a presentation, present only numbers and figures and statistics and make it fun. He is unfortunately dead now, but his work lives further on. When you have done the assessment with ULS, Youth Level Service, you get a profile on the 8 topics that it assesses: criminal behavior, family, school, peers, substance abuse, leisure time, and personality behavior. And you could see from the profile of the assessment, and we do that in Multifunc, how does the youth score in each topic. Goal with this is to define the most important risk factor. Here we see this juvenile scores high on criminal behavior. This is a static dynamic, static factor, risk factor. But we can change the future. Then we have to focus on the criminal behavior. It scores high on peers. That means that this juvenile do not have any prosocial peers or no. He have only criminal peers. That means that this is a very important treatment target. The same are substance abuse. Those other topics, moderate score, family, school, leisure time, personality, behavior, should also be in focus, but they are not so important as the topics they score high on. So this profile guides the treatment planning. Then they develop case plans. Needs, problems should be based on assessment. Goals, longer terms, outcomes where offenders should be after interventions are made, but also objectives, the offender's short-term, measurable, and verifiable steps to reach goals. To show you some examples how we do it. If from the youth level service, we find that the youth uses drugs, criminal actions, and uses violence to obtain what he or she wants, this is the reason for placement in institutions. Then we turn it to the goal for the whole treatment process. That will be good function within society, without drugs or violence, and without criminal behavior. Then we use the youth level service to find how is the situation on each topic. In this example, in family circumstances and parenting problems assessed with youth level service, we found that there were inadequate supervision. The parents have difficulties in monitoring the youth. They are not able to control his or her activities. Difficulties in controlling behavior. The parents have problems in exercising control over the youth's behavior, and the youth disobeys instruction and is out of control. And there were poor relationships between father and youth. There is a particularly poor relationship between the father and the youth. It was hostile or uncaring, or there were other significant conflicts between father and youth. This was information from assessment with youth level of service. Then we turn it to goals. Goals are how the situation should be after the treatment programs. Then we want the parents to have adequate supervisions. They should know where and with whom the youth are, and they should be aware of his or her activities. The parents should be able to control the youth's behavior, and there should be a better relationship and communication between father and youth. This is written goals for the treatment process, and the juvenile and the parents and the social welfare in the municipalities are aware of that. So all of the participants have documentation that this is what we try to reach within the family. Within school education, we assess from the youth level of service that the problem is disruptive behavior. In classroom, the youth is engaged in acting out behavior or other disruptive behavior within the school. We found low achievement, the youth was failing a subject, or there were other indications on achievement problems, and he or she was performing below expected level. This was found from the youth level of service. And there were truancy. The youth is missing school days without legitimate excuses. Then we turn this to goals. Long-term goals for education was to increase presence and participation at school, to succeed in absence of disrupting behavior in school, and to succeed that he or she was performing in accordance with expected cognitive level. And these goals, every team in the multifunctional institutions have, they know about it. So the pedagogical team focuses on these goals within school. Each team have their own responsibility. We need in Multifunc to have long-term goals, but also short-term goals. Change of behavior and function, change of dynamic risk factors. We have two long-term goals. How should the situation look like when we end the aftercare? But they also have to define, based on the assessment, what should we succeed with the first month, the next month, the second month, the third month? How should the situation be before the juvenile moves home again? These they have to plan already at start, at intake. We are giving them 2 weeks from intake to have ready treatment plans. And so we know that it's not sure that they succeed after 2 months to reach the goals that was planned. But then they always have to do analysis. What is the barriers? And make new interventions to get rid of the barriers. But they have to define, how should the plans look like over time? What have we to focus on first, second, third? Because they have to do it step by step. For example, juvenile who use drugs. You cannot think of to get rid of substance abuse within 1 month. They have to think about what should we do first before we could expect to get rid of substance abuse. Maybe the first thing is to control the juveniles, to stop him from getting drugs. When we have serious criminal juveniles, we have to, the first period, we have to have a goal of not escaping, not running away. And we have to work together with the juveniles. How should we avoid that you run away? We had one boy, serious criminal juvenile. His father was gang leader. And this boy ran away into heavy criminal milieu in Oslo. And the institution phoned the police and asked for help. And they said that, no, this milieu is too dangerous. We don't go there. So the institutions phoned the boy's father, who was in prison, and told him about the problem. And the father said, my boy should not be like me. He will return. The next day, the boy was brought back to the institutions by two heavy muscular criminals. And they told him, never come back to us. So it's possibly also to have a cooperation with criminal parents. And when we evaluate it, the profile could look like this. This is scores on the different topics before placement. And when we do a new assessment after placement, it could look like this. The risk level is reduced. The most topics are better, but are still some risk. And this risk that is left is a risk. Especially in this case, medium risk on friends, peers. And this is important that someone follow up. That was what I was thinking of today. Any questions?
Before we move on to the questions, which of course are welcome from all over the world, it seems, I'd like to say thank you, Tor, for that very comprehensive talk about how Norway approaches very difficult children who are into serious offending. I think it's very interesting to hear that it's difficult to get the institutions to work consistently over time. What can happen to disrupt a well-run institution? It's interesting to know how the teams are structured within your institutions. And it's interesting also to know that this is a dynamic program which is looked at for each child weekly, monthly, until you are seeing the treatment work to push them from the high risk to lesser risk in some of the areas of the 8 areas that you follow, and their 42 sub-items. So thank you very much, Tor. I think that was a very illuminating insight into what you do in Norway. I now would like to open the floor to questions, and perhaps just to start the ball rolling, I would like to ask our panel of Tor Andreassen and Sylvia and Stephanie, who's I cannot see on the screen, but I would like to ask them about instruments, which are quite a big section in the book that the project has put together. And what do we need to assess? It might be that each of our 3 speakers has, in their own way, addressed what we need to assess. What instruments do we need to assess? What factors do we need to assess? Thank you. So perhaps we can start with Sylvia, who I can't see.
Okay, thank you. I'm here. Hopefully you can hear me.
I can hear you, Sylvia.
Okay.
Yes.
Yes, I already talked during my presentation.
You did.
Okay, when it comes to risk assessment tools, there are some really, really great. But when it comes to, let's say, Croatia, you have to buy a license, you have to pay for translation, and I think most European and non-English speaking countries have the same problem. So I would say that we have a limited availability of already proven or evidence-based tools. As a result, we tend to make our own, but as I already said, I think when it comes to planning a treatment, interventions and prevention, we should use evidence-based instruments that have been scientifically scrutinized. And even then, there might be some problems. Psychopathy is actually a risk assessment tool. Psychopathy measures are risk assessment tool that have received more scientific scrutiny than any other risk assessment tool I have know of. And you've seen the presentation, we still don't know if it's a good risk assessment tool or not, honestly. And I just wonder, when we use something that has been developed for the use inside certain country or a county, I just wonder what we get. And how can we plan treatment with something that hasn't been proven either reliable or valid, and we have no idea how good predictor is? Well, how can we plan anything if we don't know what we are actually measuring?
Thank you very much, Sylvia. And I think that there's a culturally appropriate aspect to assessments too, isn't there, to the tools? Thank you.
Yeah, I've been listening to Tore's presentation. It's excellent, but if we can't, let's say, use this assessment inventory because our services can't follow. Well, we can't do it because of the staff shortages and staff burnout. So basically, it's excellent inventory, but as a country, we can't follow up everything that is supposed to be done for delinquent youth.
Thank you, Sylvia. And Stephanie, would you like to add anything about instruments and their use?
Yes, thank you. I was just thinking that I think there is a difference between why these instruments are used. On the one hand, as Sylvia and Tore explained, it is important in order to to assess what kind of treatment is needed for young people, how they can be helped, supported, treated on these dynamic risk factors. But on the other hand, I think in the juvenile justice system, these instruments are also used to guide, for example, judges in their decision making and what kind of sentences are implemented. And in that regard, I think they should carefully look at the results, as Sylvia already explained, that there's a lot of insecurity about the validity of the outcomes of these risk factors, and that of course not only the risk for reoffending is weighing into the decision of a judge, there are also other factors that need to be taken into account. As also one of the participants indicated in the chat, that when a young person is a repetitive offender, not only the risk for reoffending, but also the impact that his crimes have had on the society, for example, merit a criminal response. I think we should distinguish between those different purposes of risk assessment in this regard.
Thank you. And Tor, is there anything further you would like to add, or was your talk so comprehensive that we'd fully understand your system?
Just to say that even if youth level service is not normed in Norway, but we are doing that now, it's much better to use that instrument than not to use anything. And it is normed and validated in many countries. And there is a lot of research on youth level service that concludes that this instrument is predictive for future criminal behavior. And we have translated it to Norwegian and got the translation accepted by the license havers. And we pay for use of it. And we had never succeeded in doing this if we had not had people in important positions that said this should we do. We should use the money that it costs. We should use the training that's important, and so on. And that I think is important to get any change. That those people in positions who decide are with us.
Yes, I think the political aspect to this, because it's quite clear that employing so many highly qualified professional people to work with very serious offenders over long periods of time, it's never ending, in fact, does mean that governments have to buy into this way of handling serious offenders. And to go back to the point that Stephanie made about judges using them, I think I have said in the book that has been published and is online, as Jolanta has said, I have said that in the years that I was sitting in a youth court as a magistrate in London, without being able to call upon the Youth Offending Service to actually provide the bench, the sentences, or the deciders of remands into custody or not remands into custody, to not have a comprehensive report guiding us, telling us what we don't know, we can't possibly know, but they can find out, and they often do know, the job would have been impossible. You just cannot guess what to do with a child. You have got to be guided. And in doing that, one of the questions I wanted to ask the panel is, what about when someone requests a report? What about the way in which that request is worded? Because the requesting person must have an aim in mind. Do they make that aim clear to the writers of reports or not? Have you any experience of that? Perhaps we can go to Sylvia again first.
When I used to work with juvenile delinquents, we usually were not given an aim for a comprehensive assessment. So basically what we did, we were just writing reports on, because you've seen it done similar way. So maybe now it's different, but as I recall, we basically, in most cases, we never got a name, or we were never told why it's supposed to be done. They are, we are supposed to appraise the risk of a person, of a young individual, and that's it. But what they are going to do with this report, we usually did not have any follow-up information.
Thank you. Stephanie?
Yeah, in the Netherlands, in more serious cases, a forensic psychologist and sometimes also a forensic psychiatrist are asked to draft the report, and then they are guided by specific questions that are set already, and they ask about whether the young person has a mental disability which needs treatment. So they are going to do all these psychological tests on mental disabilities, and also more a general assessment on the social background, and then indicate whether a treatment, and then specifically closed institution, is necessary in that case. And I think in the more lenient or less serious cases, then the question is more broad about what advice can the Child Protection Board give on an appropriate measure or sentence for this young person, based on the assessment. But then they will not go very deeply into mental disabilities, more a general assessment on the life and background of the young person.
Thank you. That's very understandable. And Tor?
Yeah, they ask specific questions that they want an answer on,
yes.
But they never say anything about how you should assess this.
Yes. Well, I suppose that brings us neatly onto training, because perhaps some of us, and I would include myself in that, might not know what questions we want to put. So the training of the users of reports, like defense lawyers or like prosecutors or like judges and magistrates, should include understanding of what can be done with an assessment. to point you in the direction of the best interventions to bring about fulfillment of the aims, which are to stop recidivism and to turn children's lives around so that they become law-abiding. I know that one of the things when I was used to be requesting reports was to give an indication that at the end of the day, this was likely to be custody, or at the end of the day, this was likely to be not custody, or at the end of the day, we did not know whether at this point in time it would be custody or it would not. So we could at least on 3 broad ways, they say custody, not custody, all options. And if it was not to be custody, then the sort of intervention in the community that we would really like a lot of information about. And I think that indication from everyone who was sitting in the youth courts in England and Wales, that was a requirement to make sure that the reports that came back to us were of use in the final analysis of sentencing and disposal of juveniles. So I think in the chat box earlier, I think there was a question about involving parents in the assessment procedure. There is a question I haven't managed to scroll. Ruta, can you read out that question for us then, please?
The multifunctional program for the education of children, should it also be provided to parents? Yeah, so the question is mainly about involvement of parents, because as a very good question actually, because Sylvia yes. also mentioned that children should be in the good environment in order to change their behavior, yes. But in a lot of cases, family cannot manage to be a good place for the children to change their behavior. So question is for all presenters, any programs are provided for parents in your country?
So shall we start with Stephanie this time?
Yes, thank you. I think in the Netherlands there is attention for the role of parents, and that parents need maybe some help in this regard as well. But mainly the focus is on the young person and his or her development and the goals that are set basically for the young person. So there have been these treatment programs like multisystemic therapy, for example, that have been implemented. But they are not used on a large scale because they are quite invasive for the whole family, and the whole family needs to cooperate, including the parents. And I think that's one of the difficulties sometimes to have them all motivated to engage in this program because of one of the children is coming in contact with the police. But I think also at diversion level, there's more attention now also to involve parents in what kind of interventions they're applying to their children, and how parents can also supervise their children better in the future.
Thank you. Tor? It's clear from your talk that there's great involvement of parents in your programs.
Yes, it is. Even if some of the parents never will be able to be perfect parents for the juveniles, we think that they still will be parents in the future.
Absolutely.
And if we could give them some training, they could be a bit more supportive for the juvenile when the juvenile is 23, 25 years old and the social welfare are out of this. I also was part of a consensus statement report that is on the internet consensus statement about residential treatment of juveniles. And one of the conclusions, it was 33 researchers from 10 countries who made this report. And one of the conclusions was a mantra: nothing about us without us.
Yes.
That the parents should be fully involved as partners, not as parents, families who have failed. And in Norway, we have a tradition to have meetings within social welfare between school, social welfare, psychiatry, to discuss the family, the parents, fully before the parents are invited into the meeting. And I think that's a bad idea. I would not trust if I was the parent. I would be fully involved as a part. Mm-hmm. And this, I think, is important, regardless of how the parents function. Involve them fully. They know the child, they know the situation, and if you could give them a little bit more, to be a little bit more better parents, that will be good for the juvenile.
Thank you, Tor. The parents are parents are parents, and they are always going to be a child's parents. Sylvia?
In Croatia, there is a intention to involve parents if possible. And parents who usually get involved are the ones who are really motivated. They are not good parents, but they are motivated to make some changes. However, if they are uncooperative, it's very difficult to involve them. I don't think we have any specialized programs for parents. And if we have them, it's usually on, let's say, community level or some social welfare center level, but on a grand scale, I would say no. So there is an intention. A lot of psychologists, social worker, special educators actually work with parents, but I don't think we have a proper program which aims parenting skills or helping parents on a grander scale once a juvenile is sent to an institution or is removed from a family.
Thank you. I will just add that it was incumbent on me to look at whether a parenting order should be put in place for parents of children who were before the court and were under the age of 16. And these parenting orders required parents to attend a course for about 3 months on parenting skills. There was some research done to follow up on the efficacy of these orders, and it was found that whereas the training in parenting skills had some effect, didn't have any effect on the boy or girl that was before the court at the time. Younger children seemed to benefit from the fact that parents did have more skills in handling them when they became difficult. So parents had learned something and it did become applicable in some instances. The other involvement, of course, as Stephanie mentioned, a lot of cases now are diverted from court and parents are keenly involved or should be involved in those diversionary processes. An official one that is decided by the court in England and Wales is a referral order for first offenders, particularly to a panel which is made up of community members who can draw on the expertise of health professionals, etc. And the contract that is drawn up between the panel and the child is signed off by the child and the parent has to go to those meetings. I think it's sometimes a bit of an eye-opener for a parent to know exactly what is in their children's minds and what they have been getting up to. So the involvement of parents, I think, is a very good thing, and I'm pleased. I can't remember where the question came from, but I think Ruta did. I think it was from Croatia.
Hello, sorry, Avril.
Hello.
It's Neven.
Yes, Neven.
Yeah. Also from Croatia, if I could add a little bit to this discussion and and continue on Sylvia's comment about Croatian
You're
system.
very welcome, Neven.
Thank you. Well, what I think it's always good, and what is something that we do have in Croatia, is that the involvement of parents is legally written quite well in the legal acts, in the Youth Law Act. The problem, as Tore mentioned earlier, as problems in Norway, the same situation is in Croatia as well, is that we do not fully use potentials that we have, and the system does not always follow every legal letter as we have it. So if you look at the way the assessment is prescribed in the law, it says that it has to assess both individual but also family circumstances, parental elements, and the assessment has to be very, very holistic. The question is whether in practice it is conducted in the way that it's written in the law. The second thing is that when every youth that is sentenced, whether it's a diversion measure or it's an educational measure or any type of more severe correctional measure, individual treatment plan has to be written, and this individual treatment plan that is written has to be signed by parents as well. Yes. So they're the ones who have to read it and have to sign it in order for it to be applicable. If they do not sign it, then the social pedagogue or social worker, psychologist who is working on the case has to inform the court and the state attorney office that it's not possible to continue with the measure because the parents do not agree with it. And there is also a legal possibility for parents to get extra measures from the court and to get extra obligations from the court for their parenting skills and for their parenting behavior. But this is something that is not pointed out enough during in practice and during the practice of sentencing. So I always kind of try to look, do we have good legal background to involve parents and to do the assessment? And then are we really using it? So I think this communication is also very good to transfer results of importance of parents into practice and to maybe sensitize practitioners to really use the legal possibilities to involve parents in the whole process.
Shall we just throw this question of parents and their involvement open to anyone else from a different country, maybe? No, it seems quite quiet out there. There aren't any comments about the importance of parents in a child's life. I believe in the assessment process that goes on in the Asset Plus assessment system here in England and Wales. There is a whole questionnaire directed only at parents. And it has a lot of questions on it. I mean, I can't remember how many, 20 questions, something like that. So the parents are involved in the assessment process itself. So when it comes to signing off, they have had an involvement in the in the production, if you like, of assessment, which I think can only be a good thing. So can we now then turn, we've touched slightly on how much good intervention costs, and that speaks to resources and having buy-in, as it was put, I think, by Tor, from the politicians who control funding. And it's not just the resources, it is when you get the resources, the workloads that those human resources carry, and the quality of the people who are doing the work. So I don't know if perhaps anyone, we can start with Tor this time, would like to add anything to the workloads that people have. If you are, I think you had a little bit of a comment about in your institutions when an institution that had been working very well for 10 years suddenly was not working well, and that was because too many very difficult young people had been, seriously violent young people had been placed there at once. So there is a serious consideration of the workloads.
And there is always a problem about economy and costs.
Yes.
And the stakeholders want to fill up the places. If we have 8 places for 8 juveniles in one institution, yes, they want it to be full all the time.
Yes.
So we see that it's a continuous struggle for the institutional leader to think of how many juveniles could we manage at this time. We have one unit who have a very serious juvenile for a time. He ran away and came back with a gun and threatened the staff. And this did something with the staff. So the institutional leader managed to get the stakeholders to understand that for the time being, we cannot take any more juveniles. Mm-hmm. But it costs. And the stakeholders count only on the price per day in yes, institutions. But we try to turn it to have a short as possibly stay at institutions. And we calculated it, and then we get less costs for each juvenile mm-hmm, than other institutions who have longer treatment stay in institutions. Yes. So we have not to count only day price per day, but price per youth treatment.
Yeah.
There is a very good, I don't know if you see this.
Yes.
It's a book edited by James Whittaker, George Del Valle, and Lisa Holmes, Therapeutic Residential Care for Children and Youth. It's very good, and there is a chapter in this book, Calculating Costs for Therapeutic Residential Care by Lisa Holmes. It's worth reading.
I think before I move on to Sylvia, I think that for years and years and years, people arguing against detaining children in prisons, in institutions that are closed, have come up with costings for keeping someone in a closed, secure institution where very little work is done with them, and the cost of looking after someone in the community where they're expected to go through quite an onerous program. The costs are very high for loss of liberty, less high, plus a program when they're treated in the community. But you run up against a political question there about what the politicians like to be seen to be doing, to be being active, and imprisonment is sort of quite often at the forefront of their minds, even though it's not value for money. Sylvia?
I would like to say we basically have no idea what is the cost benefit. Well, if you compare costs and benefits of different residential care for juvenile delinquents, it hasn't been done. But when anything new is trying to be introduced in juvenile justice system, usually the main excuse why it's not going to happen is it costs money.
Yes.
And it costs money to educate people. For a long time, I would say that any changes done in juvenile justice systems come from bottom, not from up down, but from bottom up. When it comes to workload, lots of people working with juvenile delinquents are overworked. Some institutions don't have enough staff. Also, staff usually doesn't have an opportunity for supervision and educations
of themselves
necessary to work for juvenile delinquents. Also, mental health of health providers is usually put on a back burner. So you have people who work a lot, who actually try to manage with what they have, but nobody take care of them. I'm talking about experts, usually practitioners who deal with, especially the ones working with the most serious delinquents we have in Croatia.
Thank you. Stephanie? workloads?
Yes, I think for the Netherlands and for many other countries, of course, the number of young people involved in the justice system have dropped in the last 10, 15 years. So that also made that in the Netherlands quite some juvenile criminal institutions were closed because the beds were not filled anymore. But nowadays, especially, we have a lot of problems with funding for children in care. And you also see the intersection between care and justice systems, yes. Where, for example, children who are in the justice system and need certain treatments, there's no availability in the care and protection system. And also when they turn 18, for example, local municipalities are responsible for providing care and support to their citizens, but there is no funding for that. The whole decentralization has taken place in the Netherlands to local communities, which involved many budget cuts as well. But for the because the numbers in the justice system are relatively low of children who are sentenced and deprived of liberty. I think because of those low numbers, the services are quite good for them. But if they need other kinds of treatment, especially in the community, it's much more difficult to establish that.
Well, thank you. I think that we have covered many of the points that I had made a note of today on resources and quality and workloads and who refers and what are the aims of referral, and do the users get what they're actually hoping for? Well, only if they actually specify what they are looking for in a report. And unless there are any more questions or comments from Jolanta or Ruta or Nevin, who has now gone offline.
I see that we almost covered all questions that we have in chat.
Thank you, Ruta. So it remains up to me then to say thank you very much to our panelists for being with us for the whole morning today. They are very busy people, so we do appreciate it. And wish you well, of course, in the great work that all of you do. And thank you to Ruta and Jolanta for arranging this very successful morning. Thank you to everyone.
Dear colleagues, hello once again. Law Institute of the Lithuanian Center for Social Sciences, the A Child project leader, welcomes you back to our second session of the final project conference. We are continuing with providing you with our presentations made by rock stars in the field of juveniles individual assessment. Professor Stephen Case. Professor Stephen Case is a criminologist working at Loughborough University in UK. He specializes in youth justice issues, particularly the development of child-first approaches to working with children who offend. These approaches are positive, constructive, and non-criminalizing. Professor, it's our pleasure. The stage is yours.
Very much. Thank you for the invite. Hello, everybody. I hope you can understand this presentation clearly enough. I'm going to talk about a new approach to working with children who offend that's being developed in England and Wales and also in Northern Ireland. And by children, I mean 10 to 17-year-olds in our country. And it's called Child First. It's the guiding principle for everything that we do with children who offend in our youth justice system. And it's a challenge, a direct challenge to risk-based approaches to working with children who offend. Because my career of 20 years or so now has been split into two. The first decade I spent challenging risk-based approaches, risk management, and the understanding and responding to children who offend based on their risk of reoffending and the problems with doing that. And in the second half of my career, I've developed an alternative approach with my colleague, Professor Kevin Haynes, which is called Child First, which is now becoming popular. So I'll take you through what I think is wrong with risk assessment and risk management in youth justice, and why we developed Child First through our research and our work with practitioners in England and Wales, and why we think it's a better approach. If I can move there we go. So in the 21st century, in the new century, millennium, risk-based approaches to youth justice became very popular, particularly after the 1990s. In the 1990s, we had a period of rapid globalization, particularly in Western Europe, which led to lots of social, political, economic changes, and lots of anxiety and insecurity in different societies, particularly in the UK, around the risk that was being presented to our futures of social problems, and particular social groups presenting problems to the kind of this stable future of our society. And a particular social group that was focused on was children and young people, which has always been the way within politics, public opinion, media, academia. We have always focused on children and young people as an unpredictable, uncontrollable group that needs to be managed as a way to help adults to manage their own insecurities and anxieties about the future of their society. Because children are relatively powerless, children are very easy to scapegoat, children don't have a voice in society, they don't vote, they don't work necessarily, particularly below the age of 18 in the UK. So Ulrich Beck famously talked about we were living in a risk society from the 1990s onwards, characterized by risks and threats to our well-being. A political movement of neoliberalism swept across Western Europe and I suppose the Western world, Australasia and North America as well. Neoliberalism is a particular movement that places personal responsibility on people for their actions. So somebody who offends is personally responsible for that offending. They are primarily responsible for their offending behavior and stopping their offending behavior. And that's a strategy called responsibilization, which was labeled by a very excellent criminologist called John Munsey, superb criminologist and a hero of mine. And it also led to another neoliberalism. The climate of neoliberalism created another movement within youth justice, a dominant strategy within youth justice. And by youth justice, what I mean is how we respond to children and young people who break the law. So youth justice is a collection of strategies and structures and theories and programs and interventions and philosophies. But the dominant strategy for youth justice in the 1990s and in the 21st century has been neo-correctionalism, which is the idea that we should correct children and young people when they offend because there's something wrong with them, because they have deficits, because they have weaknesses, because they have flaws, and we as adults and professionals who know better should correct them. I was talking to Jolanta earlier on about, I know in Eastern Europe there was a social scientific movement called defectology in the 40s and 50s, which pseudo-psychological, which is the idea that people who offend have defects. There's something broken and wrong. And neo-correctionalism as a strategy for youth justice came along, particularly in the UK, to replace two other strategies for dealing with children who offend, which had been dominant for 100 years. One was welfare, and the other was justice. Welfare-based youth justice means we focus on children's welfare and their needs and their well-being and their health as our primary focus when we respond to offending behavior. So offending behavior is a sign that there's something missing in the child and some needs that need to be addressed. And justice-based approaches respond to the offense. They respond to the deeds rather than the needs of the child. And they prioritize the offense or the offender. And these two competing approaches were dominant in the UK and in North America for 100 years, until neo-correctionalism came along. And it emerged in this climate of modernization as well. In the 90s, in the 2000s, youth justice systems and criminal justice systems wanted to rapidly modernize because of globalization, wanted to become much more evidence-based in everything that they did, much more cost-effective, much more closely managed and controlled by central government. So this is a strategy of managerialism. We also had a review of our youth justice system in the mid-1990s in the UK, which was called Misspent Youth, which basically highlighted the need for a new approach to youth justice, as did political arguments and academic arguments. Throughout the 1990s, a new paradigm, a new model for understanding and responding to children who offend became very, very popular in academia, based in developmental criminology, and it was called the risk factor prevention paradigm, which I'll talk about in a second. The work of David Farrington and Per-Olof Wikström and Hawkins and Catalano in the USA, but particularly David Farrington, Professor David Farrington at Cambridge. So what we had in, I'm going to say the UK more than Western Europe because it's the context that I'm talking about, is we had this perfect storm of circumstances, socioeconomic changes, political changes, technological changes, globalization, an increasing focus on risk, increasing focus on individual responsibility, an increasing focus on modernizing and managing youth justice, and a rapidly growing evidence base that not only that welfare and justice-based approaches to youth justice weren't working, which was wrong, exaggerated, misleading, but we had an appetite and a need, a political and an academic need for a different approach to youth justice. And there was a growing evidence base around the idea that you could identify risk factors in children's lives at an early age that helped to predict later offending behavior. And this is called the risk factor prevention paradigm. So there's a huge evidence base growing across Europe and Australia and North America and the Western world, the global north, around this risk factor prevention paradigm. Identify the key risk factors for offending and target them through intervention. This was David Farrington's work mainly. Did a very famous study, a longitudinal study in England and Wales called the Cambridge Study in Delinquent Development, which is very worth reading. So the risk factor prevention paradigm became a practice model. It was evidence-based. There was lots and lots of research conducted, lots of longitudinal and cross-sectional studies identifying exposure to these very negative experiences in childhood in children's personal life, in the school, in the family, and in the neighborhood, that if children were exposed to these negative influences, negative experiences, negative circumstances, deficits, problems, personal weaknesses, they were more likely statistically to offend in the future. So these were called risk factors, and these risk factors were considered to be the best targets for future intervention, which I suppose made a lot of practical sense, a lot of cost-effective common sense. And Farrington supported this risk factor prevention paradigm, which he helped to create, I suppose, because it was very, very friendly, very practice friendly. It was very easy to understand. It's a very straightforward and common sense approach. It's based on evidence, so it's cost effective, it's considered to be effective, it's considered to be efficient. There was a growing evidence base for it. Practitioners understood it. And the way that it was translated into practice, the most common way that the risk factor prevention paradigm was translated into practice is through risk assessment, which has become the dominant form of trying to understand children's offending behaviour in practice in the UK and North America. There's been a large body of risk-based assessment and intervention, which is broadly labelled risk management as an approach to youth justice. What we tend to do, and what we've done in the UK for 20 years, is use assessment tools to identify, to measure risk factors in children's lives in what we call psychosocial domains of their lives, so psychological domains, so in terms of their emotions, their thought processes, their attitudes, and their immediate social environment in their family, in their school, in their neighborhood, in their peer group, in their lifestyle. So what we're not looking at with risk assessment, what we're not looking at is broader features of the community or socio-structural factors or political factors, or like poverty, like unemployment, like children's interactions with criminal justice agencies like the police. We're not looking outside of the child for the causes of offending behaviour. We're looking within the child. This is an individualised approach, a very psychological approach. What psychological effects and behavioural effects are factors in the child's immediate environment having on them, and what should we then target through our intervention? So all of our understandings, if we use this paradigm, this model for understanding children's lives, the way that we understand, the dominant way that we understand children's offending in Western Europe is individualized, is psychologized, is risk-based, and therefore the dominant way that we respond, we intervene in these children's lives is risk-based. Because you can only find out about what you ask about. So if you only ask about what are the risk factors in children's lives, that's the only framework you can use for understanding their lives, and therefore that's the only way you can respond. And what we've done in the UK, and when I say the UK, what I'm really talking about is England and Wales, because England and Wales has had its own youth justice system since 1998. What we've done in the UK for the last 20 plus years is use a risk-based assessment and intervention framework where we measure, we categorize, we score risk levels through risk assessment, using risk assessment tools. And then we scale the level of intervention to a child's risk category. So what we do, we traditionally used a risk assessment tool which was called ASSET, which had a number of questions about risk factors within it, within a number of domains of risk, psychosocial domains. Then we added up the score, and we decided if a child was high risk, medium risk, or low risk of reoffending based on their risk score. And then the frequency of the intervention, the intensity of the intervention, and the duration of the intervention was scaled to that risk category. So they got much more intervention for longer if they were considered to be high risk. And that was called the scaled approach. And of course, the interventions that we use, I don't really want to go into the problem with what works interventions, but we use a particular, because we haven't got time, but we use a particularly limited group of interventions, which are all risk-based and based on an experimental criteria called the Maryland scale, based on the work of Lawrence Sherman, which is called the What Works interventions. And they have their own limitations too. But the basic, I suppose the fundamental principle here is that we are using a particularly focused, narrow way of trying to understand children's lives to guide how we respond to children's lives when they offend. And in fact, for the first 10 years of risk-based assessment and intervention in the UK, in England and Wales, we don't call children who offend children. We call them young people or youths. And we talk about youth offending, which is a label in itself, to the point that youth, in inverted commas, youth, has become a negative, a stigma, a label, criminalizing label in England and Wales. It implies problems. So language is really, really important here. And also perspective. What we're doing, or what we've done through using the risk factor prevention paradigm, is employ a particular lens or way of looking at children and a particular evidence base that understands children based on risk. The risk that they're going to reoffend in the future. And there are serious problems with this. And I'll go through them now. I've written a book about it. I wrote a book called Understanding Youth Offending in 2009, which was a criticism of risk-based youth justice, essentially. Risk assessment as the main tool for understanding children and for shaping how we respond, youth justice responses, is deficit-based. It's based on the idea that children have got problems and flaws and there's something wrong with them. They have deficits, there's something lacking in them that needs to be corrected by an adult. Yeah, that's the neo-correctionism that I talked about earlier on. So that's a particular way of looking at a child, a particular way of understanding a child as somehow broken or lacking or flawed. And this kind of label applying to a child, not also deficit-based, but it also implies that a child may be dangerous or threatening. So that kind of label, it feeds into external understandings of children who offend, in the media, in politics, in public opinion. And we had a particular climate of fearing children in the late 1990s in the UK, that was stirred up by politicians, and which this evidence base helped to stoke, helped to fuel it. based around a child murder that had happened in the early 1990s. And also based around a new government under Tony Blair, our former Prime Minister, who had a particular view that children should take more responsibility for their actions. So again, that's neoliberalism that I was talking about earlier on. So the youth justice policy within which risk assessment and risk-based youth justice became popular, it was the creation of a small group of politicians. It was a creation of Tony Blair, our Prime Minister, our Home Secretary, Jack Straw, and his deputy, who was called Alan Michael, who all had professional experience as magistrates, and two of them as magistrates, and personal opinion that children weren't taking enough responsibility for their actions when they offended. Why am I telling you this? Well, because, and I'm sure you know this, that youth justice approaches don't become popular based on academic evidence or what's the most convincing academic evidence or argument. There are so many other influences on why youth justice approaches become popular, or particular approaches to working with children more generally become popular, largely political. They're based on political influence. They're based on vote winning. They're based on political agenda, personal opinion. So when governments, such as our government, suggest that their approaches are evidence-based, often they've developed the approach beforehand, and then they find evidence to suit that approach, to justify that approach afterwards. This is a classic case here. So the evidence base for risk assessment, the evidence base for a risk-based approach to youth justice is partial. And what I mean by partial can have lots of different meanings. It's incomplete, so we've only got part of it. It's poorly understood, so we only partially understand it. And it's biased, because partial can also mean biased. And it's very narrow. It's one group of evidence, one set of evidence amongst lots of different sets of evidence, lots of different ways to understand children, lots of different ways of working with children, but it's become dominant for political and socio-economic reasons, modernization, globalization, neoliberalism, etc. And it's become dominant to the exclusion of largely to the exclusion of all other ways of understanding children. And it's damaging because it's deficit-based, because it's very negative. Risk-based youth justice is entirely founded on negatives. Children are negative when they offend. Children are full of risks when they offend. The priority for youth justice should be to prevent offending, or to prevent reoffending. A prevention agenda is largely negative, because what it ignores is anything positive about promoting positive outcomes in that child's life, providing a quality of life, citizenship, social capital, capacities, strengths. And I'll talk about this when I talk about Child First. So if the major success is measured by preventing a negative outcome, that's not positive. That's just, at the very best, that's neutral. The youth justice system of England and Wales, the primary aim of the youth justice system of England and Wales is to prevent offending. Well, that's a neutral focus. And to do so by to pursue that aim by trying to identify what is wrong with children who offend, to assume that they've simply offended because there's something wrong with them, or they're not able to take responsibility for their actions, that it's to assume that it's nothing that we have done to these children as adults, as a society, as criminal justice agencies. is a very negative way to proceed, is a very narrow understanding, and it's very adult-centric. It's very focused on how adults understand children's lives. It's very focused on how adults want to understand children's offending. Because this whole movement of risk-based youth justice has come from to address adult concerns about children being out of control or children's behavior being difficult to understand, children being threatening to adults because we don't understand them. And what we don't do because of this, when we use risk assessment tools, we don't ask children what they think. The risk assessment tools that we've used in England and Wales have been adult professionals administering a tool, a checklist, a tick box checklist questionnaire to children with very, very little chance for a child to contribute, to participate in any meaningful ways. Yeah. So what we say is we do youth justice to young people and children rather than doing it with them. And that's problematic. And particularly when you get into talk about children's rights and the United Nations Convention on the Rights of the Child. The UN Convention on the Rights of the Child is based on 3 principles. I hope I can remember them. Protection, provision, and participation. I think that's right. Well, risk assessment, assessing children's lives based on measuring the risk factors that they display in their lives, is not protecting them, because what it does is criminalize them. It labels them and stigmatizes them and marginalizes them as bundles of risks, of threatening, as dangerous, as needing to be controlled and managed, as risky, rather than as children experiencing problems, who've had traumatic experiences, who've had adverse childhood experiences, who are victims of abuse and neglect. And you know, I'm sure lots of people here know that children and young people who offend are much more likely to have been victims of abuse and neglect and trauma and had terrible experiences in their lives than children who don't offend. There's a reason for that. So these are some of the reasons we should be exploring and responding to in youth justice, but we're not. We're individualizing the causes of their offending. We're blaming children, essentially, and holding them primarily responsible for their offending behavior. In fact, we're holding children primarily responsible for for dealing with their offending behavior. They're children. They have far less capacity to take responsibility for their actions than adults do, but we're treating them like they're adults with adult capacities. They're not developed. Where was I? Yeah, so protection, the UN Convention on the Rights of the Child. So we're not protecting these children, we're criminalizing them. We're responding to them based on their risk category. We're responding to them based on what they might do in the future, and not what they have done in the past or what they need. So we're labeling them as risky. And because of that, what happened in England and Wales, we're sucking them into the youth justice system rather than pushing them out of the system into other support systems. Because we're saying we're dealing with the offence first, or the young person as an offender first, and saying you need to get further, deeper into the system and have more and more intervention. And this approach is called interventionism. But the problem is, the deeper the child gets into the system, the more and more embedded their label as an offender becomes. So we're dealing with these children as offenders first and not children first who have also offended. So it's not protecting these children. It's not working holding their welfare as primary or their best interests in line with the UN Convention on the Rights of the Child. It's not offering them a broad range of provision that they need to address their support needs. It's focusing on what they need to stop them reoffending, narrowly speaking. And we're also administering youth justice processes that aren't allowing these children to properly participate, because we're doing youth justice to them. We're telling them what's wrong with them, and we're telling them what we're going to do about it. And then we're blaming them if it doesn't work, even though we generated these understandings through adult-centric processes rather than working in partnership with the child. And so the UN Convention is just blown out of the water by risk assessment and the assessment of risk factors, is what I'm saying, not assessment of risk to the child in the future, but the assessment of risk factors. It's an extremely oversimplified approach as well, because we're only looking at a very, very limited number of influences on the child's life. And we're not looking at others, like I said earlier. We're not looking at social structural factors, political influences, broader neighborhood influences, the influences of adults on those children, the influences of others on those children. We're looking at what's wrong with that child in a small section of their life, psychological aspects, family, school, immediate neighborhood and peer group. That's all we're looking at. We're also reducing all of these potentially complex influences to a number, a risk score. It's such a dramatic oversimplification of children's experiences, of their circumstances, of their views, of how they negotiate their lives and how they construct the problems that they face and their interactions. We reduce it to a score, high, medium or low risk, and then we respond to that. It's outrageous in methodological terms, but it's easy, it's simple, it's straightforward, it's easy for practitioners to understand. It's easy for practitioners who are very busy. It's easy to simplify a very complex set of behaviours, offending, into something that could be easily targeted. If you go back to the early slide about the risk factor prevention paradigm, David Farrington said it's very easy to understand for practitioners. Let's see, the paradigm is easy to understand and to communicate. But because something is easy and simple doesn't mean it's valid, doesn't mean it's good. You know, not always the simplest solution is not always the best, right? And in this case, it certainly isn't, because offending is a very complex construction, set of behaviors. And also, because this is such an oversimplified, a prescriptive tick box exercise, risk assessment, it's deprofessionalizing. So practitioners, their experience and their expertise is undervalued. It's underutilized. It's a very risk assessment in England and Wales became a very technical exercise, very closely managed, technical. Practitioners were told how to conduct risk assessment. They were told how to understand children's lives and how to respond to children's lives. And all of their expertise and their experience and any idea that they could build a relationship with that young person to help them to understand their lives, that was thrown away because the government had so much faith in this very simplistic, technical, easy to manage, easy to evidence approach that fit political priorities for evidence-based, effective, efficient, economical youth justice. But what became lost through this whole process was any notion that we're dealing with children. And this is the problem that me and Kevin Haynes had, and lots of people in Wales actually at the time. These are children. They're not adults. They're not bundles of risk. They're not statistics. They're children. And so around the end of the first decade of the 21st century, in England and Wales, Child First started to gain popularity, I would say, as an alternative principle for youth justice that challenged and attacked and addressed the problems with risk management. It became popular because, for at least two reasons. One is because myself and Kevin Haynes had conducted quite a lot of research in local areas, particularly in Swansea in Wales, that had adopted a child first approach, that had adopted an approach that put children first and offenders second. They were very brave in Swansea to do this because the government were telling them to prioritise risk. And in Swansea, they didn't want to do that. So we managed to get quite a lot of evidence that putting a child first when responding to their offending was effective, would prevent negative outcomes, but would also promote positive outcomes in the child's life. So we developed quite a strong evidence base that's grown now around child first approaches to youth justice. And secondly, the organisation in England and Wales that managed the youth justice system, which is called the Youth Justice Board for England and Wales, they had a new leader called Professor John Drew, and he was very much of the same mind as us. And we spoke to him at length about our concerns with risk management, and we sent him our book, and we sent him our thoughts on what the alternative approach should look like. Because up until then, risk management had had a lot of criticism about what was wrong with it and how it was very anti-child and criminalising and all the things I just said. But there wasn't much, not many people were talking about alternatives, ways of doing youth justice. And we thought that we had a way. And that way, that child first, it was originally called Children First, or Children First Offenders Second. We thought that was the way. And it's subsequently been adopted by the Youth Justice Board of England and Wales and the Youth Justice System of England and Wales as a way of tackling risk and doing youth justice differently. The Youth Justice Board have said that previous risk management approaches to youth justice don't prioritise children's rights. And we've got a shocking record of in the UK, I'm afraid to say, of meeting the requirements of the UN Convention on the Rights of the Child, particularly with children who offend, children in the youth justice system. The risk management was responsibilising children beyond their capacity. So remember, responsibilising means holding them primarily responsible. And there was a suggestion that we've got one of the lowest ages of criminal responsibility in Western Europe, 10 years old. The idea that 10-year-olds fully understand their criminal actions and the consequences of their criminal actions is based on no evidence whatsoever. It's nonsense. It doesn't make sense to think that a child aged 10 or 11 or 12, and I use those ages because they're children, youth offending should be conducted by youths, teenagers, adolescents, 13, 14, 15, if at all. But we call 10, 11 and 12-year-olds youths when they offend. We assume that they've got the psychological, cognitive capacity to fully understand their actions, to fully empathise with their victims, and to engage with youth justice interventions. And the evidence base around cognitive development and the evidence base around moral and emotional development just does not suggest that that is valid at all. But our government continue to insist that this is evidence-based and continue to insist that 10-year-olds can fully understand the consequences of their actions. And the reason that they do, just as an aside, is that in 1992, we had a child murder in England and Wales of a young boy called Jamie Bolger. He was killed by, he was 2. He was killed by 2 10-year-old boys. And so when the new government came in 1997, the age of criminal responsibility was effectively lowered to 10. The presumption of innocence that we had for 10, 11, 12 and 13-year-olds, which is called Dolly Incapax, presumption of innocence, was abolished based on one freak event and based on political agenda. And the Youth Justice Board has acknowledged the other criticisms of risk management. These are criticisms that I've just made on the previous slide and criticisms that I've been making for years, that risk management relies on a deficit model of managing offending risk. So looks at what's wrong with children rather than what their capacities and strengths and potentials are, solely looks at what's wrong with them and negatively labels and stigmatizes children when they offend, does not work with them constructively or in any kind of future-focused way, doesn't really allow them to participate in any meaningful way, nor their families, and ignores the criminogenic effects of system involvement. Now, criminogenic means likely to create more crime, crime causing. If something's criminogenic, so we have a ridiculous situation here where becoming involved in the youth justice system can actually make children more likely to offend in the future because it stigmatizes them and labels them as an offender, because it subjects them to too much intervention, because it makes them resentful, because they become involved with other, if they're in custody, for example, they'll become involved with other children who've committed crime, etc. There's a very, very famous study, which I would urge you to read, called the Edinburgh Study of Youth Transitions. And they found that the biggest risk factor for further offending is contact with the youth justice system. Okay, so think about that. We've got an approach to youth justice called risk management, which increases children's likelihood of contact with the youth justice system because it's deliberately interventionist. It deliberately wants to correct these children, deliberately wants to work with them and intervene in their lives. Often for supportive reasons. I'm not saying that the youth justice practitioners or policymakers are bad people that want to make these children worse, but they've fallen in love with an approach which is criminalizing and makes children more likely to become involved in the youth justice system. And often that involvement can make these children worse. So it's counterproductive. And the history of youth justice in risk-based intervention has proven this, that risk-based intervention at the very best doesn't do anything, and at the very worst makes children worse. The very first risk-based intervention study in criminology was called the Cambridge Somerville study in the 1950s. Its long-term findings, it made children worse. The Edinburgh study shows contact with the system makes children worse. Yeah, the first ever study of risk factors in youth justice in the 1930s in America by the Gluecks showed that the biggest influence on children stopping offending was maturation, which means growing up. It was not intervention. And yet we've got a system based on a paradigm called the risk factor prevention paradigm, which deliberately intervenes and interferes in children's lives more and more and more, and therefore does more harm than good, and is not based on evidence. So the Youth Justice Board have created this guiding principle of youth justice, which I believe strongly should guide their future assessment of children who come into the youth justice system or who are on the fringes of the youth justice system, and should certainly guide intervention with children. It's a developing principle. It should guide everything that we do with children. It's not prescriptive. It's not a model. It's not even a strategy at the moment. It's a guiding principle, a way of working at every stage of the youth justice system. And it's got 4 elements to it, 4 components, which are based on my work with Kevin Haynes in the early part of the 2000s, which identified in Swansea the features of youth justice practice that were the most effective, according to children and according to families and according to practitioners. So this is a distilled version of what we created, which was called the positive youth justice model, which we wrote about in a book called Positive Youth Justice, which really is the evidence base for Child First. So the Youth Justice Board that manages the youth justice system in England and Wales and practice of professionals says that Child First Youth Justice should see children as children. We should prioritise their best interests, their needs and their capacities and their rights and their potentials. So when a child comes into the youth justice system and we try to understand them and work with them and assess them, we should treat them as a child, underdeveloped, lacking in development, lacking in capacity, but also having views and capacities and potential. We shouldn't treat them as a mini adult. We shouldn't treat them as fully responsible, and we shouldn't treat them as an offender. We shouldn't label them. We should understand that they're a child. And the UN Convention on the Rights of the Child, up to the age of 18, you're a child. Okay? Adults should take responsibility for ensuring that children successfully negotiate their way out of offending. We should work with them as children in welfare-based and rights-based and needs-based ways, not risk-based ways. We should focus on positive outcomes. We should promote their strengths, their capacity, their potential. We should look to the future. We should develop working relationships, supportive relationships with the child that allow them to participate, that allow them to develop a positive pro-social identity that they can take forward, that's sustainable. And there's quite a significant body of work around this pro-social identity development as a theory of change for children. There's a model called the Constructive Resettlement Model by Neil Hazel and Tim Bateman, who worked with children who were coming out of custody and resettling into the community, and found that pro-social identity development is really, really important. So this isn't negative. This isn't focused on just preventing negatives. But by doing this, by approaching children in these ways, working in these ways, you will also prevent offending, reoffending. I've got a huge evidence base to suggest that that happens. But you're also promoting positive outcomes and promoting children's strengths and sustainable approaches and sustainable desistance, stopping offending for good. Positive outcomes are things like educational achievement, employment, citizenship, social capital, staying in the family, positive activities, those kinds of things, you know. They're children. We want these things we want these successes for our children. So why don't we also want them for children when they offend? They're still children. That's the point. Collaboration with children, really, really important. remember I talked about risk assessment and risk-based approaches do youth justice to children. They exclude them, they marginalise their voice. The UN Convention on the Rights of the Child is all about the child's voice, Article 12. Children's voices in what happens to them in decision-making processes. I'm really, really strong believer in this. Active participation and engagement and inclusion. I still cannot believe how in England and Wales we developed an approach to youth justice, risk management, that was so prescriptive, so controlled centrally, that it largely excluded the voice of the child in understanding their lives and what might work to help to support them in the future. And it also largely excluded the voice of the practitioner, the professional, and not to mention the family. The two most important, what we call stakeholders in understanding children's lives and responding to them when they offend, the child and the professional, almost totally ignored by the risk factor prevention paradigm. So arrogant, so reductionist, so narrow, not evidenced, shocking. So now child first approaches, which would include the child's meaningful collaboration during their own assessment. And that's what we're trying to do in England and Wales now through a revised assessment process that places far more emphasis on talking to the child about how they understand their lives and how they experience problems in their lives, rather than creating a collection of tick boxes that we say, yes, that's present, or no, that's not present. And then adding up a risk score and giving child an intervention. So important, collaboration with children as a principle. So important in understanding their lives. Children's understandings of their lives can't possibly be the whole story, because I've talked about how they're underdeveloped cognitively and emotionally. But surely they offer a very, very, very important perspective, as do practitioners. And finally, the idea that we should promote diversion. The vast majority of children who offend are better off being dealt with by systems and support services outside of the youth justice system, because the youth justice system is criminogenic. It makes it can make offending worse. It's focused on the offence. It's often focused on justice. It's often not the best place for the child to be if we want to prioritise their welfare, their social care, their health, their mental health, psychological issues, speech and language problems, abuse, neglect, trauma, etc., etc. It also avoids labelling the child as an offender and giving them a criminal record. So we should prioritise diversion from formal justice systems, and that's what we do in England and Wales. And that's not saying that we shouldn't assess children or try to understand their lives. Assessment is really, really important to help to understand these children's experiences and their lives so we can respond to them more appropriately. But we shouldn't just do that based on factors related to their offending behaviour. And we don't need to do it within a formal youth justice system that's going to make the situation worse. And there's a lot of work. I've just produced an evidence-based document, which I'll send to Jolanta afterwards, which gives evidence for all of these principles, their success in policy and practice and academic research over years and years. This is a fully evidence-based approach that should underpin assessment and intervention with children who break the law. I'm going to miss that because I've talked about that already. I just want to finish by saying that there are some threats emerging to Child First becoming a reality in England and Wales and across the world. In my context, internationally, we've got economic austerity, but Child First assessment and Child First approaches are actually more economical. They don't criminalise, They don't subject children to lots and lots of costly intervention unnecessarily. What they do is actually streamline processes, so they shrink the justice system. This is why this isn't particularly always popular with practitioners in the youth justice system, because it threatens their identity, because what we're arguing here is for less youth justice. We're asking for a child to be dealt with in a kind of a joined up way through whole systems approaches that don't necessarily involve youth justice. I don't know about Brexit, actually. I think that's probably a bit. Well, I think the threat of Brexit in England and Wales, of course, is when it's actually happened, that the government now might turn their mind, cast their eye to other things. I was saying to Jolanta earlier on that one of the reasons why Child First has become popular in England and Wales and gained a strong foothold in policy and practice is because our government have been looking the other way and have not been interfering. So political agenda hasn't been so much of an issue. But we have constantly government instability and uncertainty, and socio-political and economic instability is always a threat to any kind of new approach to policy, however framed. And so if our government, as it is at the moment, ever decides to start looking at youth justice, they might have another view. But at the moment, austerity, Brexit, these political distractions are the friend of Child First. In America, Trump, for a long time, they are good because what they promote is local agendas, local areas, developing approaches that suit their local problems rather than too much government interference. COVID's obviously a huge issue because Child First approaches rely on engagement and participation, and that's become a lot harder as a result of lockdown restrictions and also delays in justice. But actually, we've shut down a lot of youth courts in the UK, and there's been less youth justice. So fewer children coming into the system as a result of COVID. But the problem is the lack of contact. It relies on a meaningful partnership with children, and that's harder to do from a distance. Although there are child-friendly ways of building relationships virtually. So it's a challenge. Certain issues in Child First assessment have not yet been addressed, such as Black and minority ethnic disproportionality in our youth justice system. We've got the Black and ethnic minority children are overrepresented in the youth justice system of England and Wales. And that's a significant issue about how we do a Child First approach with particular groups that are even more marginalised than children who offend, how we do Child First approaches with girls. We shouldn't just assume that one approach fits everybody. If the media starts to turn their attention to youth crime again as a new moral panic, which it has been traditionally in our country for years and years, then Child First is going to come under sustained challenge. And the knife crime epidemic that was occurring in the UK prior to COVID was a significant threat because it was being attributed falsely to children and young people. And so that's a threat and a challenge, as is, I don't know if you're familiar with the Adverse Childhood Experiences Agenda, ACEs it's called. It's becoming really popular in the UK, in North America, that children who've suffered adverse negative childhood experiences and what, like the abuse and neglect and trauma, are more likely to be offenders in the future. And that's a challenge for Child First because on the one hand, yes, of course, it's true. And it's all the more reason why Child First should be the way we deal with these children, because they are victims of what has happened to them, not threats based on what they've done. But the problem with the ACEs agenda, and I hope it doesn't visit itself upon you, but it might, to be very, very wary of, is that it's being used in America as a risk factor prevention paradigm, a disguised version of the risk factor prevention paradigm. So ACEs, adverse childhood experiences, are being quantified and represented as risk, basically as risk factors, which does all the same types of damage to the child as the risk factor paradigm. It criminalizes, it labels, it responsibilizes, it blames. So we're running the risk of, again, of blaming children for experiences and influences on their lives which weren't their fault. Abuse and neglect as a risk factor. Black and minority ethnic status as a risk factor. Poor treatment by the police as a risk factor. Okay, and these are all challenges to child first assessment, because assessment is crucial, is the central part of youth justice in England and Wales. Assessment is absolutely crucial. Intervention is absolutely crucial, but it shouldn't be focused on measurement of risk factors, and it should be focused on the child first and foremost, understanding that person who's come into contact with the youth justice system or who has offended in some way, understanding that they are a child and have everything that goes with that child identity in terms of their capacity and ability and lack of power, lack of voice. So that's where that's really where this has come from, as a challenge to a very, very negative risk-based approach, and as a more modern, sustainable, humane, rights-based, child-friendly approach. Oh look, that's the book that it's based on. Youth Justice. Horrible, horrible cover, I'm afraid. And so there's a large evidence base, which I'll send to Jolanta, which will, I'm sure she can make available to you, an evidence-based report on each of the principles of child first. Yeah, and that was the last part of the slide. I hope that's made sense, and you can see where it's come from, whether you agree with it or not. That's the journey into child first that I've had over 20 years.
Oh, thank you, Professor. Your presentation provided a lot of food for our brains to digest. You rock. Thank you very much. And I will ask our colleagues who currently hear us and watch us to use this unique opportunity and to ask questions in the chat box. Professor will respond them during the discussion forum. And now let us, dear colleagues, welcome back. Needless to say that multidisciplinary approach is simply precious in the field of individual assessment. So we had lawyers, sociologists, and psychologists presentation today. And our next brilliant presenter that I'm sure you have been waiting for comes from the field of psychiatry. So Alexa Rutten works as a child and adolescent psychiatrist in a hospital for forensic child and adolescent psychiatry, and in outpatient department for forensic child and adolescent psychiatry again. She performs a psychiatric pretrial forensic assessment reports. Her PhD research concerns autism and delinquency in juveniles. Ms. Rutten is always a trainer of trainees specialists for those who want to become child and adolescent psychiatrists. So we are excited to hear your presentation. Please.
Okay, thank you for your introduction. My topic is about trying to speak the same language after emphasize the importance of speaking the same language, especially of the delinquent juvenile, the topic of today. I'll tell something more about the situation in the Netherlands, because this is an international conference, and I think some things and some things I'll tell today are the same in all the countries, and everyone will recognize who work with this group, but there also are some differences, I'm sure. Why is it so important to speak the language of the juvenile? It's important when you work with juveniles in general, also juveniles who are not forensic and who are not suspected of committing a crime, because when you want to make contact with juveniles, and juveniles in general don't like to go to a psychologist or a psychiatrist. Especially not to psychiatrists, they always say, I'm not crazy, I don't need that. So you have to make contact, and you have to try to speak their language. But when you have to do with juveniles suspected of having committed a crime, it is even more important, because you are not only their therapist, but sometimes you have to deal with them in another situation. For example, the police is usually the first one who comes in contact with a juvenile who is suspected of committing a crime. But also in the Netherlands, we have the Child Protection Council, because in the Netherlands, and I think it's the same in all the other countries, we say it's not usual, not normal when a child is committing a crime. So we have to look what's the matter with that child. Is there something wrong with him? That is what we think when a juvenile is committing a crime. Of course, when adults commit crime, it's also not normal, and it's not what we want, and it's not usually, but sometimes they can choose for it. But children is another suspect. So the child protection in the Netherlands is always, every child who comes to the police and to justice has contact with a child protection council, and he or she is looking, and he's also doing that in the weekends, in the nighttime, is looking if this child in this police office, if he needs some help. Is everything okay with his parents, with his living situation, with his health, with his school? So in a short time, they make a report of about 10 pages, and they look at all the aspects concerning the child. Another person who has to do with a child in the Netherlands when they come to police and justice is the probation, parole officer. It's the one who is following the juvenile going to trial, and sometimes he or she is also the one who looks if the child go to the treatment, and if he's not, he tells it to the prosecutor, because it is possible that the child is in the home situation, but when he's not going to his therapist, maybe he has to be forced to go to jail, even sometimes. Of course, also the judge has to do with the juvenile when later in the process, when there is a trial, and he wants to know a lot of things from the juvenile, so he has to speak the language of the juvenile. And the last years, there's a lot of judges who are interested in what's going on with that juvenile for example, I'm specialized in autism. I had to speak with a few judges and prosecutors, and they want to know everything about autism because they really want to talk with the juvenile, and they want to know how they have to talk with juveniles with autism, for example, because they have another way of thinking, and they want to understand it, and they want to speak the same language of the juvenile. And I think that's good that they have that interest and want to be better in that. Also, when after the trial, when the juvenile is going to treatment, or perhaps he's going to jail, but he also will have some treatment. He has to do with forensic psychologists and psychiatrists, and also therapists. And later on, I'll tell you something about the assessment, and then the juvenile also have to do with forensic psychologists and psychiatrists. Some characteristics of the juveniles juvenile delinquents. I don't think that's different in other countries, but usually juvenile delinquents have difficulties with their school, with their education, low intelligence, also because of the use of drugs, they stop with their school. Also because of their behavior, they're not anymore allowed to stay at the school. So they change schools a lot of times. Sometimes even when they're very young, they have to go to special schools for children with psychiatric problems, or schools for learning problems. In this group, and that's the same as with adults, there's a very high percentage of psychiatric morbidity. A colleague of mine did her PhD about 10 years ago, and she found a number of about 80% of the juveniles who have psychiatric morbidity. And it is very often that it is unknown, that the first that the juvenile commits a crime and comes in contact with police and with justice, and after that with a forensic psychiatrist and a psychologist, and then there is a diagnosis, and it was the first time that someone was diagnosing this child. So unknown autism, unknown ADHD or other problems, it's very familiar. And sometimes even parents say to me, it's very bad and it's very sad that my son has committed a crime, but now my son gets the right treatment, and we wait for it for years, and no one was looking very careful, and now at least it is a fact that we know the diagnosis and he can be treated. In this group, there are also a lot of family problems. Very often parents who are not capable to take care of this child. It is a child with problems, but the parents have problems themselves, or are very young, or there's violence in their relation. Or the mother is standing alone because father left a family very early when the child was only a baby, and so they're not capable to take care of this difficult children. So there are a lot of problems, and also parents with their own psychiatric problems is familiar. Also a low socioeconomic situation, living in a neighborhood where they live with many poor people, financial problems, no work. The children want the expensive clothes and things and telephones, and they have no money for it. So it's very big problems. Education dropout are already mentioned. And what we see is, and I think it's the same in your countries, that a lot of these children are traumatized because of domestic violence or situations they met at the street. I promised to tell you something about psychiatric and psychological forensic assessment. Only in a small percentage of all suspected juveniles there comes an assessment, a report. About 2% of all juveniles have contact with police and justice because of committing a crime, and of that percentage, only a few percentage, a small percentage, has this investigation by a psychiatrist or a psychologist, and it is because the prosecutor, that's the one who asked for this assessment, wants to know something about the development of the child, if there is a psychiatric disorder, and if there is a connection with the crime the juvenile is suspected of. And they want to know something about the criminal responsibility, if there are deficiencies in development, the mental state of the juvenile. But the most important question is, like I already said, is there a link between the offense the juvenile is accused of and the mental state? Because sometimes a child is autistic, but there is no link with the crime. But usually there is a link. For example, autistic child has a special way of thinking, and that when committing the crime, that way of thinking makes him committing that crime, because there was miscommunication, or he was not able to think about another solution for a problem, for a social problem. So there, in that cases, there's a very clear link. Sometimes it's more subtle, not so clear. As you can understand, people with ADHD, they're impulsive, so they are more often doing things and thinking after they did, but not always there is a link. So it is difficult to find out. It's difficult because juvenile doesn't want to talk about it sometimes. Sometimes the crime was about half a year ago, and you have to talk with the juvenile. How did you feel doing the crime? What was you thinking before? What was you thinking after? And sometimes it's very difficult for the juvenile to tell you. So that make it difficult. But we try to tell something about it, because it's very important for the prosecutor and the judge. Because and it's also important for the juvenile, because we hope to give an advice for treatment with what is important for everyone, but also for the juvenile, of course, because we also do a risk assessment, And of course, we don't hope to see the child again committing crimes. So that's the most important reason to do this investigation and to make this report. That we hope it was the last time he did such a crime. Especially in severe offenses, reports like this are asked for, and usually not in small offenses. Now I would like to tell you something about what sort of treatment we can advise. And it's the same treatment we offer in our clinics. The hospital where I work, it's a forensic psychiatric juvenile hospital. It's the only one in the Netherlands. It has 25 places and there are mostly about 21 places are occupied by boys, and only a few girls are there. And we have different groups, and we also have a small FIC group. It's a group of children who need very intensive care. They have special individual programs, and they need a lot of rest and structure. But there are also groups where the juveniles are some further in their treatment, and they're allowed to go out and to go sometimes go home in the weekend for a few hours, and to go to the shopping, to the supermarket, and cook at the hospital, and do working things and treatment outside the hospital, and go to school outside the hospital. So it depends on the moment of the treatment. And we also have an outpatient department, and the children who come there, they live at home, and they visit the outpatient department about once a week. The most offered treatment there is this list. Brains for Use it's training, and it has as a goal to the aim is to control the use of drugs. It's not that they are not allowed to use any drugs, but you try to find out with juvenile what is his wish about using drugs. And usually they like to use drugs in the weekends, but not all the days like they do now. That can be an aim. For example, in the Netherlands, we have a big problem with cannabis. There are, I think, almost a few million people using it. Also, a lot of juveniles, and some juveniles come in very big problems because of the use of cannabis, because they do it every day. And some of them even more than once a day. So that's a problem. And the problem of alcohol is also a big problem. And we also have other drugs like cocaine, ketamine, and a lot of other drugs. I think it might be the same in your countries. We also offer TACT. It's training aggressive control, and it's a training, and it consists of social skills training, moral reasoning, and impulse control. And we also have EMDR, because a lot of the children are traumatized, and well, I think you know it is the eye movement desensitization and reprocessing, cognitive behavior therapy, and other sort of psychotherapy we also offer. Some children use psychopharmaca. If there's a diagnosis of ADHD, of course, we offer to treat that with psychopharmaca. In autism, usually it's not necessary to use medicine, but there are some people with autism who are very who are so aggressive and have so many problems with the outside world, and to get it under control, and have sensations of their head being so full of thoughts and everything that they need a low dose of antipsychotic medicine, and that can be very helpful if you use it for a short time and control it very careful, because of course it's not a good idea to use that for a long time, but sometimes it can be helpful. And there are a lot of people, young people in our clinics who ask for sleep medication, but that's usually it's a problem that they are sleeping at daytime and using drugs, or they use drugs outside, and now they have to get a new sleep rhythm. So we don't give them. Usually we don't give them tranquilizers or sleep medication. Schema therapy is also possible. Family therapy is very important. We also, the parents have an important role in the treatment. And crime analysis, we do it with all the juveniles in our hospital. And it is a few sessions with a therapist, usually about 8 or 10. And the last session, it's a presentation of the juvenile, and he or she is telling about his crime and how he felt before, and it has as aim that the child will understand himself better and understand how he come to the crime, and we hope to prevent it in the future, of course. The juvenile delinquents, where do they stay? Well, most of them, they stay at home, and they also stay at home when they have the treatment. They can come to our outpatient department. But of course, it depends on the offense. If there was a very severe offense, violent offense, they usually start in jail. We call it juvenile justice institution in the Netherlands. Some of the juveniles, they stay in closed youth care when they are below 18 years old. And a few of them, they stay in the juvenile forensic psychiatric hospital. You can imagine there are only a few because we have only 25 places in the whole Netherlands. Maybe it's good moment to tell that in the Netherlands you can be prosecuted, so you're punishable from the age of 12 years old and older, of course. And the juvenile criminal law is until 18 years old, but since about 10 years we have the possibility to apply the juvenile criminal law up to and into 23 years old. And that's a good development because we know a lot more about the immaturity of the brain, and there are a lot of children between 18 and 23 years old who have developmental delay and other problems which make it more suitable to apply the juvenile criminal law, and so that's a good situation that we have the possibility now. To return to my subject about speaking the same language, at this slide you see a picture of a movie. It's called Autidelict. It's a Dutch movie. That's the reason I don't show part of it. But maybe in your countries you also have some material like that. It's made by an autism unity for and they give education to everyone about autism. And the movie is very helpful and give information about the thinking of an autistic juvenile who commits a crime. There are 2 cases in this movie, and you see in the movie it's very impressive the arrest by the police and the arrival at the police station. And they're going to the judge, and you see the parents, and you see the juvenile telling about how he experienced everything with his autistic brain. And that makes, when you see that movie, you can understand more about it. And I showed this movie to some judges, and they were it was good education for them. To continue exchanging information is also very important if you want to speak the same language as the juvenile. We also have to do, of course, with multicultural aspects. There live a lot of people from other countries in the Netherlands, with also their juveniles and children from other countries and with other culture. So you have to know about it and to learn about it, because it changes every day. And maybe the most important is the feedback of the juveniles themselves. So we have in the Netherlands, organized by our psychiatry company, a youth board, and it exists of a few juveniles who stayed in a psychiatric hospital, not forensic, but they had psychiatric problems. And sometimes they appear at television or at the Congress, and they tell us, I mean psychologists and psychiatrists, what they think that's important for them to behave against them, the way of speaking, the way of asking them things. And I think that is very important. They can give the best feedback to us about how to behave against them and how to talk with them and how to get information from them. So now I have my take-home message, and I hope after that you have any more questions. I hope that I made clear today that it is important to try to speak the same language as a juvenile. Of course, it doesn't succeed often, but you can try, and you have to learn in it, and you have to stay learning in it. And it is important in different situations in forensic assessment. It is important to make a good diagnosis. It's important in a judicial process. It's important for the prosecutor, for the judge. If you want to ask the juvenile things about what happens during committing the crime, you have to try to speak the same language, and sometimes it depends if there is a disturbance, a mental disorder, you have to understand something about it, or the way of thinking of the juvenile. At least you have to try. It's also important in the treatment process, of course, and it's important in aftercare. So it's important to improve the legal process, the diagnosis, and the treatment. Thank you for your attention. It was a pleasure and an honor to might speak with you here today. It would be even more nice if we could meet each other in real. Maybe sometime it will possible. I hope to see you all at the FCAP Congress. I don't know if every one of you know the FCAP. Please send me a mail if you want to know more about it. The FCAP is the European Association of forensic, child and adolescent psychiatry, psychology, and other involved professions. And they organize every 2 years a congress in a European country. And for everyone who is interested to work with this group, it's an interesting congress. So maybe that can be a place to meet each other again. I hope you understand my talk, and maybe there are some questions.
Mm-hmm. Thank you, Alexa. For us lawyers, it's always healthy to hear the perspective of other specialists from other fields. It's always enlightening, and it's always terra incognita. Now, since we are short of time, I'm gonna pass the stage for the discussion forum. The discussion forum will be led by our colleague Neven Riccias from Zagreb University, Faculty of Education and Rehabilitation Sciences, who have been extremely helpful partners in this project. Zagreb University, my compliments. And Neven, please, the floor is yours. You can read some questions from the chat box. And maybe you can add something from your perspective. You're welcome. I believe that we will have at least 10-15 minutes of discussion.
Okay.
Thank you very much, Jolanta, for everything. So this is our final conference of the project, but I also believe that we have opened some of the questions and we have opened some of the delicate issues that are related with the assessment during this conference as well. Of course, it's a never-ending story, so we will have to continue on working on ways to improve the implementation of assessment for the best interest of the child. If I look at the chat box, what I can see is that one question was already answered by Stephen. So for his previous lecture, we also have one comment where Bernardica from Croatia has commented on Stephen's presentation that besides risks, we should also focus on strengths. And she referred to the Good Lives model. So if Stephen is here and would like to maybe comment on Good Lives model and focusing on strengths of the child, that would be good because it was related to his lecture. I don't see Stephen here.
And the question of the Good Lives model, was it for me or for the
It was for Stephen. It was during his presentation.
Yeah.
But I would also like to invite everybody to write questions for your presentation as well, Alexa. Yeah. If they have any. But I don't think that Stephen is here.
If you would like to ask to answer about the Good Life model, you are very welcome to do so. Again, it's going to be different in any way.
So it seems that Stephen left the Zoom. So Alexa, would you like to comment on Good Lives model
and what's exactly, because I do know the Good Lives model. A colleague of mine, she did her PhD was about it, and recently another colleague, she did a latent class analysis, and she looked to the different juvenile delinquents in our hospital and give them more color, and said some of them had more psychiatric problems than others and more problems at that, and they also have their talents and things that they're important for them. So at our institution there's a lot of interest for the Good Lives model, and because as a therapist and as a doctor and we are, when we work with this group, we are used to look at the problems, but for the juvenile, it's very helpful to succeed in some things and to be heard about what they need and what they want and what's important for them.
Mm-hmm. I agree. And what do you think? How important is it when you say speaking about with the language of a juvenile? What's the importance of language in making a report with juvenile? I mean, professional relationship, and to what extent should a professional go not to be still taken seriously, or not to sound ridiculously if he tries too much to level with a young person in his linguistics?
Yeah, that's a very good question, because it would be ridiculous if you try to know everything about their music and other things if it has not your interest, and just to speak the same language. That is not what I mean. I mean that they have to know what your function is, and maybe it's not different in juvenile psychiatry in general. It's not also it's not only the case when you work with delinquents, but you try to make contact, and it is important that you don't have to you are not forced to know everything in one talk. You take some time, maybe one day you can speak a few minutes with them, and other day some longer time, and sometimes they have learning problems, so you have to speak at another level. You have to show that you have respect for them, but they also have to have respect for you, of course. So that are things that are important, and these juveniles, a lot of them are not used to talk with any adult at all. They've lived in families where even during dinner time, no one was talking. They were just eating their food at the television, and now they come in a hospital and they sit at a table and they have to talk with the group workers, and so that's very different. So that are some aspects of the language, but I agree that you don't have to try to know everything of the world of juvenile, and it's also not possible because it changes every day.
And it is something that is there. I mean, it's a generational gap, of course, and it is something that has to stay within different generations, but we just have to try to understand it and get closer to it and be respectful to it.
Yeah. I don't know if you mean that with your remark, but in our hospital, we work with people of very different ages. Mm-hmm. So young people and older people, women and men, more women, but and juveniles are more boys. But we also have some people from other cultures, and we also have experienced workers. So they have stayed in the hospital themselves a few years ago, and they followed education. And that's a separate group, but they also work in staff and have a role to talk with those people here. Not only the juveniles in the forensic hospital, but also in other hospital, other parts of the hospital here.
Mm-hmm. Okay, thank you, Alexa. It is. Well, now it is 3 o'clock, which is the time scheduled for the end of our conference. Since we did not have any additional questions, and I wouldn't like to take more time, kind of just to wrap up with the things that we heard today, is that we started with Stephanie's lecture, where we heard about assessment within the criminal justice system and the process, and different purposes of assessment, different phases of criminal procedures. And I think it is something that we have to keep in mind. What is the purpose of the assessment? Why are we doing the assessment? Is it for making the decision, or understanding what we have to work on in creating the treatment plan and planning the intervention with the juvenile? Sylvia was critical on different instruments and which assessment tool is best for use, and do we have scientific evidence for predicting recidivism? And she also was quite critical on different instruments compared to psychopathic traits or risk assessment tools. Then we had Tore's lecture on the Norway model and his, I would say, approach where he was satisfied with the way they've been using YLS, youth level of service, case management inventory in Norway. And we could see how they made the positive aspects use positive aspects of this assessment to better understand the child and surroundings. And after that, we had also another critical approach from Stephen, where he was quite critical on the UK system. And I would say from his presentation that there is a risk if you only focus on risks. So if you only focus on risk and negativities and don't look at the strengths and do not look at use assessment only for the purpose of assessment and using it very mathematically, then definitely we are not looking at the best interest of a child. And in my opinion, using the risk assessment and risk assessment tools and categorizing the youth does not mean we do not communicate with the child. We do not allow him to participate and to hear his voice and the family voice. So in my opinion, one should not exclude each other, but it seems that this happened in UK practice, and he was very critical about it. So we always have to think about the purpose of the assessment. And I liked the principles of child first approach. I think these values and ethical approaches are good and valuable. And in my opinion, they can go hand in hand with the assessment itself. And our last lecture from Alexa, thank you, where we learned a little bit more about the Netherlands system and the way Netherlands approaches young offenders, especially from psychiatric point of view and forensic point of view, and where you also put focus on understanding different categories of offenders and autistic young people with autism and maybe some disorders that the professionals within the juvenile justice system do not understand as much as delinquency in general or risk behavior in general. So I do not have anything more to add. Yolanta?
I would just like to add to thank all the project partners to stay with us during this long journey. Thank you very much. And for the audience, for our colleagues who are watching us, I could just add that if you are interested in the scientific production and all the rest of the deliverables of the IA Child project as such, it is all compiled in one place at www.teise.lt, and there you can find the description of the project, our e-lessons, all the recordings from the workshops, and our presentations and PPT, and of course our handbook. So thank you very much